for the first respondent.
Yes,
Very grateful, my lord.
Yes, second respondent.
Please, your lordships. I'm Chief Dr. Charles Uwensi Edoson. I make a humble appearance for the second respondent. My learned friends, Chief Adeni Akintola, SAN. Chief Afolabi Fashanu, SAN. Sam Ologunrisha, Esquire, SAN. Sam Umar, Esquire, SAN. Abdul Muhammad Rafindadi, SAN. Omosaya Upola, Esquire, SAN. Sorry, my lord, it's my prayer for him, my lord. My prayer for you.
Yes, that's what I did.
Yes, ma'am. Olayewaju Akinshola, Esquire. Bolaji Oyun, Esquire. And Ms. Huwaila Muhammad Ibrahim. We're all here, sirs, for second. Thank you, sir.
Yes. Third and fourth.
With profound humility to my noble lords, my name is A. Malik. My humble appearance, my lords, is for the third and fourth respondents. My learned brothers of the inner bar, Babatunde Ogala, SAN, and Mutalubi Ojo Adebayo, SAN, all appear with me. Together we have our colleagues appearing with us, namely Emmanuel Uwadoka, Esquire, Yinka Ajeti Fuja, Esquire, Akintola Makinde, Esquire, Julius Ishola, Esquire, Taiwo Lakanum, Esquire, and if it pleases my noble lords, may I respectfully add one last name?
I only record what is on the list.
Sorry, my lord.
What on the list?
Most grateful, my lord. My lord, our appearance for the third and fourth respondents. Thank you, my lord.
Most respectfully, my lord.
Yes.
My name is Gabriel M. Isham.
Why didn't you submit your own list? Oh, it's here.
Submitted the list.
Yes.
My learned friends who appear with me are Ofure, Rosella Iyere. Listen.
Is it one that name on the list?
Lord, it's about 6 on the list.
Mention one long name.
O.R. Iyere, my lord.
Okay.
Number 7, P.T. Orabere, Esquire. Last but not the least, number 8, Edward Ajaba, Esquire. My lord, collectively, we respectfully appear for the 5th respondent.
Call number 5.
/2023 between Abubakar Atiku, People's Democratic Party for the petitioners, and Independent National Electoral Commission (INEC), Tinubu Bola Ahmed, and All Progressives Congress (APC).
Yes.
Umar Ilya Damagum, Acting National Chairman PDP, for the second petitioner.
May it please, my lords, this is May Agbamuche Umbu, INEC National Commissioner, Chair Legal Services, for the first respondent.
Dr. Bilal Manuje, Chairman, APC, third respondent.
One petitioner is represented before the court, as well as the first and third respondent, my lords. Other parties are absent.
Your answers, please.
We prefer respect to my noble lords. I am Chief. And with me are my learned brothers Silk, namely Itayo Tegede SN,
Yes.
Professor Mike Ozekome SN, Nella Andem Ewa Rabana SN, and my lords, permit me with respect to replace absent Abraham SN, then number 6, Professor Maxwell M. Gidado SN,
Yes.
7, Chief Godi Uche SN,
Yes.
8, AK Ajibade SN. And with us, my lords, our learned friends, Silas Joseph Ono Esquire,
Yes.
and Jude Daniel Esquire. Together, my lords, we appear for the petitioners. We are grateful, sirs.
Yes. Second respondent. Oh, sorry, first, sorry.
May it please, my lords. I am Sir Stephen Adehi. I appear with my learned friends, Senior Counsel, T.M. Inua, SAN, Al-Hassan A. Umar, SAN, Suleiman Olawale Ibrahim, SAN, and my appearing with us are learned colleagues, Nasara H. Auta, Esquire, Aminu Sadauki, Esquire, M.A. Atta, Esquire, Susan A. Imoisi, Esquire, Jamiu Aguru, Esquire, and Martins F. Ekpa, Esquire. We appear for the first respondent.
Thank you.
May it please, my lords.
Thank you.
profound humility to my noble lords. My name is A. Malik. I appear, my lord, for the second respondent. Learned Brothers of the Silk, Babatunde Ogala, SAN. Dr. Remi Olatubora, SAN. And Mutalubi Ojo Adebayo, SAN, all appear with me. And we have our other colleagues, Emmanuel Uwadoka, Esquire, Yinka Ajeni Fuja, Esquire, Akintola Makinde, Esquire, Julius Shola, Esquire, and lastly but not the least, Taiwo Lakano, Esquire. Together, my lord, we appear for the second respondent. Grateful, my lord.
My lords, for the third respondent, I am Charles Uwensi Edosawa. My learned friend, Chief Adeni Akintola, SAN. Chief Afolabi Fashanu, SAN. Sam Ologorisha, Esquire, SAN. Solomon Umar, Esquire, SAN. Abdul Muhammad Rafindadi, Esquire, SAN. And my learned friends of the Outer Bassa, Mr. Omosoya Popola, Mr. Olawaju, Mr. Bolaji Oyun, and Miss Uwaila Muhammad Ibrahim. They're all with me, sirs, for the third respondent. Most grateful, sirs.
Well, we'll deliver the judgments, but you know that we all know the rules concerning consolidated matters. Each of the petitions, though consolidated, will maintain their individual identities. So we shall treat them as such. We shall begin with petition number 4. Well, we all remember that during the preparing session, several motions were filed. So we shall begin with the consideration of these applications before we proceed to the main petition. So in this petition number 3 and number 4, the petitioner herein Allied People's Movement participated in the presidential election conducted by the first respondent on the 25th of February 2023 by sponsoring a candidate, that's OJ, Princess Chichi, agreed by the declaration and returned at the election, has via its petition filed on the 20th day of March 2023, read this court at paragraph 31 of the petition to grant it the following reliefs. 1, that it may be determined that A, the third respondent was not qualified to contest as the presidential candidate of the second respondent as at 25th day of February 2023, when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 142, sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended. B, a declaration that the return of the respondent by the first respondent or the Federal Republic of Nigeria is null, void, and of no legal effect whatsoever. The third respondent having violated the provisions of Section 142, sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the fourth respondent having violated the provision of Section 35 of the Electoral Act 2022. C, the fourth respondent who was not qualified to contest as the vice presidential candidate of the second respondent as at 25th February 2023, when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. D, declaration of return of third respondent by the first respondent on 1st March 2023 as the president-elect of the Federal Republic of Nigeria is invalid by reason of non-compliance with the Electoral Act 2022. A declaration that having regard to the joint ticket principle enshrined in Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999, the withdrawal of the first respondent as the vice presidential candidate of the second respondent by operation of law as the presidential candidate of the second respondent for the presidential election conducted by the first respondent on the 25th day of February 2023. A declaration that arising from the invalidity of the third respondent nomination, the first respondent ought not to have included the name or the abbreviation of the name or the logo of the second respondent in the ballot papers and other election materials used by the first respondent for the conduct of the presidential election held on 25th day of February 2023. The fourth respondent was not qualified to contest as the vice presidential candidate of the second respondent as at 25th February 2023, when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. An order nullifying and voiding all the votes scored by the secretary in view of his non-qualification as a candidate of the second respondent. Upon the grant of prayer 4 above, an order nullifying and/or setting aside the return of declaration of third respondent as winner of the election conducted by the first respondent for the office of the President of the Federal Republic of Nigeria on the 25th of February 2023, same having been made in violation of the provisions of Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999 and Section 35 of the Electoral Act 2022. Finally, upon the grant of prayers 5 and 6 above, and in the absence of the third respondent's participation in the presidential election held on 25th February 2023, pursuant to Section 136 sub 2 of the Electoral Act, an order declaring the candidate with the next highest number of votes as the winner of the election. The grounds of the petition as set out in paragraph 15 of the petition is as follows. Your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The respondents were duly served the petition and also responded by filing their replies. The first respondent replied to the petition was filed on 9th of April 2023. The second response reply to the petition was also filed on 9th of April 2023, while that of the third and fourth respondents was filed on 13th of April 2023. The fifth respondent also filed replies to the petition. On the 16th of April 2023, the petitioner then filed replies to the respective replies of the respondents to the petition. The respondent filed a number of motions, all of which challenge the competence of the petition. These motions were duly heard during the hearing session and rulings reserved. The first motion was filed by the first respondent. Applicant here in this motion was filed on the 6th of May, wherein he sought the following reliefs. 1. An order striking out paragraphs 2, 3, 4, 5, 6, 7, 13, 14, and 15 of the petition reply filed on 20th day of April 2023 in response to the first respondent's reply. 2. An order striking out paragraphs 8, 9, 10, 11, and 12 of the petition reply filed on 20th of April 2023 in response to the first respondent's reply. And for such further orders as the Honorable Tribunal were urged to note that the grounds for the petition or for the application are as follows. They have been reproduced in the ruling. I need not read them out. So the motion is supported by an affidavit of 4 paragraphs and a written address. The petitioner respondent then responded by filing counter affidavit of 7 paragraphs on 13th of May 2023. Same was accompanied by written address in opposition to the application. The arguments of counsel in respect of that application have been considered here in the ruling. A similar application was also filed by the second respondent on the 8th of May 2023, wherein the second respondent prayed this court to grant the following reliefs. 1. An order of the Honorable Tribunal granting leave to the second respondent applicant to file and argue this application before or outside the pre-hearing session in this petition. It should be noted that this court is sitting as the Court of Appeal Tribunal. So an order of this Honorable Court striking out paragraphs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 17 sub 1, 2, 4, and 5, paragraph 18, 19, 20, 21, 22, 23, and 24 of part B of the petitioner's reply and or the entire petition reply to the second respondent's reply to the petition for being an unnecessary duplication and or introduction of new facts unrelated to the second respondent's reply to the petition. 3. Order of the Honorable Court striking out in whole or part thereof of the witness statements on oath filed together with the reply to the petition for being irregular and in flagrant non-compliance with the relevant provisions of the first schedule to the Electoral Act 2022. The grounds for that application have also been summarized in this judgment, the same thing with the submissions of counsel. The third and fourth respondents also filed a motion on the 13th of May 2023, seeking the following reliefs. 1. An order striking out the entire reply filed by the petitioner on 20th April 2023, together with the accompanying witness statements on oath, list of witnesses to be relied on, and the list of additional documents. 2. Further, or in the alternative to prayer 1 above, an order striking out paragraphs 1, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, up to 21 of the petition reply under the heading Petition Reply to the third respondent's reply to the motion filed on 20th April 2023 to the applicant's reply to the petition. For such further orders as this Honorable Court may deem fit to make in the circumstances. The grounds have also been referred to in this ruling. We have also considered the mission of counsel. Now, it is apparent that the first respondent's motion filed on the 6th of May 2023, the second respondent motion filed on the 8th of April 2023, and the third and fourth respondent motion filed on 13th May 2023 are all aimed at having certain paragraphs of the petition replies to the respective replies of the respondent's replies to the petition struck out. The common ground in all the applications is that the averments in the petitioner's reply have introduced new facts, new issues, facts, and/or grounds to the petition. Furthermore, some of the averments are rehashed or repetition of the averments in the petition file. That those averments in the petition replies offend paragraph 16, subparagraph 1A and B of the first schedule to the Electoral Act 2022. The said paragraph to the Electoral Act stipulates that of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, the petitioner reply in answer to the new issues of fact, so that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him. And B, the petitioner reply does not run counter to the provisions of paragraph 14.1. In my view, the provisions of paragraph 16.1 of the first schedule to the Electoral Act 2022 are clear, unequivocal, and unambiguous. It does not, therefore, require any text or to be understood. From a holistic reading of that provision, it will be seen that it is meant to explain the purpose of a petitioner's reply to the reply. Is to raise answers to the defense or any fact which must be specifically pleaded and which have the effect of destroying the respondent or make it not maintainable. The bottom line is that a petitioner is permitted by the first schedule to the Electoral Act 2022 to file a reply while the respondent to the petition has in his reply raised new issues of fact in the defense, which fact the petitioner has not dealt with in the petition. However, in doing so, the petitioner reply shall not introduce new facts, grounds, or prayers tending to amend or add to the contents of the petition. I've cited the case of APC and PDP that petitions apply. It is therefore clear that paragraph 16.1 of the first schedule to the Electoral Act permit a petitioner in his reply to introduce or bring in any new issues or facts which ought to have been raised in the petition itself. In other words, a petitioner cannot, in the guise of a reply to a respondent's reply, introduce a new issue or fact which was never raised in his petition nor raised by the respondent. To do that will amount to amending or adding to the petition and also taking the respondent by surprise, because at that stage the respondent will not be in a position to react to such new issues or facts. It will therefore breach the respondent's fundamental right to fair hearing. Therefore, the petitioner is not permitted to repair or rehash his averments in the petition in such a way that it will amount to an amendment or restructuring or a reconstruction of the petition. See the case of Dingyadi and Wamako citations of like. With the state of the law as stated above, at the back of my mind are individual pleadings in the respondent's respective replies to the petition. Vis-a-vis the specific paragraphs of the petition replies complaint of. I'll start with the first respondent complaint. The first respondent complaint is against paragraph 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 15 petitioner reply. I have 5 paragraphs of petitioner reply. It is my view that paragraphs 1, 6, 7, 8, 12, and 14 of petitioner reply to the first respondent reply are competent, as they are proper replies to the first respondent's reply. However, paragraphs 2, 3, 4, 5, 9, 10, 11, 13, and 15 of the said petitioner reply are not competent, as they are either rehash of facts pleaded in the petition, or they introduce and or add new facts to the petition. Being incompetent is hereby stopped. The complaint of the second respondent is against paragraphs 1, 2, 3, 4, 5, 6, 7, 9, 10, 11, 12, 13, 14, 15, 16, 17, sub 1, 2, 3, and 4. 4 and 5, sorry, 18, 19, 20, 21, 23, 24, and 25 part B of the petition reply to the second respondent's reply to the petition. I've carefully considered both paragraphs in the light of paragraph 16(1)A and B of the first schedule to the Electoral Act 2022. It is settled law that where a respondent raises in reply to the petition issues, it will be necessary for the petitioner to file a reply to the respondent reply to the petition. At that stage, the petitioner may also file further written statements on oath of witnesses. He may wish to call in rebuttal of the new issues raised by the respondent. This is because any failure by the petitioner to reply or answer to those new issues raised by the respondent will be deemed that the petitioner has conceded to such phrase or new issues. The cases of Idris and ANPP, Bingadi and Wamako were also cited. That being so, the written statements on oath of witnesses filed along with the petitioner reply to the respondent reply and proof of the paragraph struck out accordingly struck out. In paragraphs 1 to the paragraph of the petition reply to second respondent reply to the petition are either rehash of paragraphs in the petition or introduce or added new facts to the petition. They are incompetent and accordingly struck out. I'm also of the view that paragraphs 1, 3, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 to 20 of the petition reply to third and fourth respondent reply to the petition are rehash of the vermins in the petition. They are, in my view, incompetent and accordingly struck out. This other motion filed by the first respondent on the 7th of May 2023, seeking the following relief. 1, an order of this honorable court striking out the petition for being incompetent and an abuse of court process. The grounds of filing the motion have been produced. The motion is supported by 6 paragraphs, affidavit deposed to by 1, Give Mwadike, a litigation secretary in the law firm of Dikko and Mahmoud, solicitors to the first respondent applicant. It is also accompanied by a written address filed in support of the motion. In response, the petitioner filed a counter affidavit on the 14th of May 2023, consisting of 7 paragraphs, deposed by 1 Kalu Kenneth Okorie, litigation secretary in the law firm of Mrs. O.M. Atoyo B. SAN and partners. A written address was also filed along with the counter affidavit. I consider the arguments of counsel on this motion. The third and fourth respondents also filed a similar motion on 12th of May 2023. Therein, the third and fourth respondent prayed for an order of this honorable court striking out and or dismissing this petition for being incompetent, fundamentally defective, and vesting no jurisdiction on this honorable court to adjudicate thereon. The grounds for the application have been listed. In this motion, several grounds were raised. Now it is apparent that the sole ground of this petition is stemming on the qualification of the second respondent. The issue of qualification The issue of qualification or disqualification of a candidate to contest an election for the office of President of Nigeria is a constitutional one. That is why it is stipulated in section 134, subsection 1A of the Electoral Act 2022 that an election may be questioned on any of the following grounds. A person whose election is questioned was, at the time of the election, not qualified to contest the election. The qualifications and or disqualifications of a candidate to contest an election for the office of president are stipulated in section 131 and 137 of the Constitution of the Federal Republic of Nigeria as amended. While the qualifications are inherent in section 131, the disqualifications are ingrained in section 137, section 1A to J of the Constitution. It is about that the issue of qualification of a candidate to contest an election could be a ground in an election petition, though it may also be ground a pre-election matter, where such issue of disqualification of candidate arises from the primary election of the party by virtue of section 285, subsection 14 of the Constitution. Where the issue of qualification of disqualification arises from before the election, it is an election, a pre-election matter, and an action on that issue must be instituted pursuant to section 285, subsection 11 and 14 of the Constitution. It should be noted that upon a quick and careful perusal of the pleadings and in the petition, the issue of disqualification of the first respondent rests solely on the issue of the alleged invalid nomination of his running mate, with the third respondent. The issue of invalid nomination is captured by paragraphs 18, 19, 20, and 21 of the petition. For proper understanding of the facts pleaded, those paragraphs have been reproduced. The second issue, arm of that issue is captured in paragraph 22, 23, 24, and 25 of the petition. Considering the facts pleaded above, it is clear that the claim of disqualification or non-qualification disqualification, non-qualification with third respondent is centered solely on the invalid or double nomination of the fourth respondent. However, it is the settled law that the issue of nomination of a candidate, qualification or disqualification can only be ventilated on the grounds enumerated in sections 131 or 137 of the Constitution. That is why section 84, subsection 3 of the Electoral Act 2022 stipulates that a political party shall not impose nomination qualification or disqualification criteria, measures, or conditions on any aspirant or candidate for any election in its constitution, guidelines, or rules for nomination of candidates for elections, except as prescribed under section 65, 66, 106, 107, 131, 137, 177, and 185 of the Constitution. 187. It therefore means that the conditions of qualification or disqualification are prescribed by, under sections 131 and 137 in case of person contesting for office of president. That means that where it is alleged in an election petition that a person is or was not qualified to contest election to the office of president of Nigeria, as stipulated in section 134, subsection 1A of the Electoral Act 2022, it is sections 131 and 137 of the Constitution of Nigeria that are applicable. See the cases of PDP and ANIC, Kaki and PDP, Ucha and Unwe, and Captain Idris Chala Wada and others versus Yahya Bello and others, all citations of right. That's why election has been and result declared. Such election cannot be questioned on grounds of qualification under sections 131 and 137 of the Constitution in the case of a presidential election. This postulation is supported by section 134, subsection 3 of the Electoral Act, where it is stipulated that with respect to Section 1, person is deemed to be qualified for an elective office, and his election shall not be questioned on grounds of qualification if, with respect to the particular election in question, he meets the applicable requirements of Section 65, 106, 137, or 177 of the Constitution, and he is not as applicable in breach of Section 66, 107, 137, or 182 of the Constitution. As stated earlier, the applicable provisions are Section 131 and 137 of the Constitution. It is clear from the plenitude of the pleadings in this petition that the facts grounding the petition's claim of disqualification or non-qualification of the third and fourth respondents is hinged on double and invalid nomination of the first respondent. I had pointed out earlier in the course of this ruling that the issue of qualification or disqualification of a candidate at an election is strictly the requirement of the Constitution. That it was held in the case of Al Hassan and another versus Ishaku and others, that is supplied a court by virtue of the provisions of Section 138 sub 1A of the Electoral Act. The tribunal's power to decide whether a person is qualified to contest an election is restricted to establishing the requirements of Section 177 and 182 of the Constitution against the adverse party. An election tribunal has no jurisdiction to inquire into the primaries of a political party. Close of court. It is apparent, therefore, that issues of nomination or sponsorship of candidates by political parties come under pre-election matters and should be instituted and determined before the conduct of the election. P. Shinkafi and others versus Yari and others, Ella and others versus Abo. That being so, a ground of election petition questioning the election of a person duly qualified to contest such election as required by the Constitution cannot be sustained, where it is predicated on nomination or sponsorship of such candidate. Therefore, a petitioner who relies on non-qualification to nullify the election must bring the facts of such non-qualification within the ambit of Section 131 and 137 of the 1999 Constitution. I have noted that the petitioner respondent sought to tie his complaint of non-qualification to Section 142(1) of the 1999 Constitution. That provision plays as follows. In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party or his running for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate for election to the office of president who nominated him as such associate is duly elected as president. In accordance with the above cited provision of the Constitution does not create additional qualifications or disqualifications for a candidate contesting for the office of president of Nigeria. Furthermore, Section 142 of the 1990 Constitution, along with Section 142(1) is a specific provision donating power to the president to nominate a person as his associate to occupy the office of the president. That's why subsection of Section 142 mandates that the requirements of qualification and disqualification attaching to the occupier of seat of president also applies to the holder of the office of vice president. It is therefore my view that Section 142, subsection 1 of the Constitution does not introduce the issue of nomination or sponsorship of vice president so as to enlarge the scope of qualifications or disqualifications applicable to the seat of president. There cannot therefore be a disqualifying factor of a candidate for the office of president outside those specified in Section 131 and 137 of the Constitution. It can safely be said that those provisions have sufficiently and conclusively covered the field until there is an amendment to the Constitution. See the cases of IG, ABIA, and AG Federation, also PDP and ANIC Supra. As a fallout to my findings above, I hold the firm view that the issue of nomination or sponsorship of the first respondent, being a pre-election matter, ought to have been ventilated by the petitioner before the Federal High Court, as this court has no jurisdiction to delve into the matter. Even if this court has such jurisdiction, because of action being a pre-election matter, is that to bar to Section 285, Sub 9 of the Constitution of the Federal Republic of Nigeria 1999 as amended. Having found as above, it is my view that the two motions filed by the first respondent and third and fourth respondents on 7 May 2023 and 12 May 2023 respectively have merit. Accordingly, I find that the petition is also they have merit. Accordingly, I find that the struck out were being incompetent. By a motion on notice filed on the 8th of May 2023, the second respondent for applicant got the following relief. An order of this honorable tribunal granting leave to the second respondent applicant to bring and argue this application before, or outside, or during the pre-hearing session. 2, an order of this honorable tribunal striking up grounds 1 and 2 contained in paragraph 16 of the petition for being incompetent. 3, an order of the honorable tribunal striking out 18, 19, 20 to 29 of the petition, which are predicated on the incompetent grounds 1 and 2 in paragraph 16 of the petition for being an abuse of court process. And order 4, an order of this tribunal striking up 1 to 7 of the petitioner's petition for being incongruous, illogical, and ungrantable. And 5, an order of the honorable tribunal dismissing or otherwise striking out the petition for one of jurisdiction and on the ground that the petition does not disclose any reasonable cause of action. Here's the grounds stated herein. And good night. I've considered the arguments of counsel which I have summarized in this ruling. It will be seen. It will be seen that this application is premised on several grounds. The first is that the grounds of the petition are incompetent. This is premised on the erroneous argument of the second respondent or applicant that the grounds for the petition are as stated in paragraphs 16 of the petition. A careful perusal of the petition will disclose that there is only one ground for the petition and is stated in paragraph 15 of the petition as follows: that your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The amendments in paragraph 16 as unequivocal deal with the facts of the petition. This ground for the objection to the competence of this petition therefore lacks substance and it is accordingly dissonant. The second ground for the objection is that the petition is an abuse of court process. It is premised on the fact that the petitioner's respondent had earlier instituted an action before the Federal High Court in suit number FHC/ABJ/CS/1015/2022 between Allied People's Movement and INEC and 12 others on the same subject matter as in this petition against the first, second, third, and fourth respondents in this petition and others. It was, however, deposed in paragraph 3M of the counter affidavit filed by the petitioner in opposition to this application that the matter was not determined on the merit by the trial court, who referred the matter to the Court of Appeal for interpretation. That in any case, the matter had since lapsed in 180 days for determination by law, being a pre-election matter. It is tried law that abuse of court or judicial process simply means the use of a court process mala fide or in bad faith to the annoyance of the opponent. One variety of it is the institution of multifarious actions between the same parties with regard to the same subject matter and same issue in the same or another court. A quick look at the originating summons in suit number FHC/ABJ/CS/1275/2022 will show that same was instituted in the Federal High Court, Abuja, on 27th day of July 2022. Being a pre-election matter, it ought to have been determined within 180 days, as required by Section 285 subsection 10 of the 1999 Constitution. It therefore means that it lapsed by January 2023, about a month the election in question was conducted. This petition having been instituted on the 20th of March 2023, when suit number FHC was no more alive, does not qualify as an abuse of court process. This ground for this objection is also pronounced. On whether this petition is caught by the doctrine of estoppel, it was argued that the issues raised in this petition have been firmly resolved by the Court of Appeal in appeal number CA/ABJ/CS/08/2022. Issue estoppel arises when the issue has been decided upon to finality by a court of competent jurisdiction. In other words, once an issue has been raised and distinctly determined between the parties, another party can be allowed to fight that issue all over again. The same issue cannot be raised by other party again in the same or subsequent proceeding, except in special circumstances. For issue estoppel to apply, the following conditions must be satisfied. A, the question must have decided, the same question must have been decided in both proceedings. B, the decision which creates the estoppel must be final, and the parties to the judicial decision or their previous to the proceedings in which the estoppel is raised must be the same. To determine whether the above three elements exist, the court will closely examine the reasons for the judgment and other relevant facts that were actually in issue in the proceeding. The cases of Oyekola and others versus Amudu, OSPM Limited versus Nigel Company, and Dasuki Retired versus Federal Republic of Nigeria Partition Supply. I've studied the case sought to be relied on as estoppel in this case. It is apparent that the parties in that case are not the same as in the instant petition. The issues, though the same, were not resolved to finality in the previous case. The action was struck out on ground of lack of local standard by the lower court, which this court affirmed on appeal. Thus, the objection on that ground is also discountenanced. On whether the question is statute barred, I had held in the earlier motion filed by the first respondent on 7th May 2023 and for the respondent's motion filed on 12th May 2023, which were taken together. This petition, which is premised on the nomination or sponsorship of the first respondent, is a pre-election matter. That election matter, it ought to have been instituted and ventilated by the petitioner before the Federal High Court within 14 days from the date of recurrence of the event or action complaint of. That not having been done, the course of action in this petition stands barred by virtue of section 2859 of the 1992 Constitution of the Federal Republic of Nigeria as amended. On the issue of local standing, I had also held in the previous motions filed on 7/5/23 and 12/5/23 that issues of nomination or sponsorship of candidates by political parties for an election come under pre-election. It is settled that the issue of nomination of candidates by substitution is purely a pre-election matter. The only person with the local standing to challenge the nomination is an aspirant who participated in the process of such nomination. In other words, apart from an aspirant who took part in the primary election, no other person is authorized to challenge such nomination by a political party before subsection 14 of the Electoral Act 22 and 285 section 14 of the Constitution. Sishin Kafi and another versus Abdul Aziz Ayari and Al Hassan another and Ishaku. It therefore follows that the course of action in this petition, which is rooted in the nomination or sponsorship of the fourth respondent, is a pre-election matter. Being a pre-election matter, the petitioner herein has no local standing to challenge or question such nomination or sponsorship of the fourth respondent by the second respondent. Thus, in People's Democratic Party (PDP) and Independent National Electoral Commission and others, unreported decision of the Supreme Court delivered on 26th day of May 2023 in SC/CV/501/2023. I heard the matter has been reported, but I have not been able to avail myself of the report. Held at the Supreme Court held at page 71 at page 31 lines 1 to 16 thereof as follows. Court, the provision does not make the filing of pre-election matters by political parties an all-comers affair. It is not the purpose of the provision that the floodgate of pre-election litigation be open to political parties who will hide under it to challenge the actions or inactions of rival political parties under the guise of challenging the decision or activities of INEC. The application of Section 285, Section 14C of the Constitution does not extend to political party walking into the affairs of another. The position of the law has always been that no political party can challenge nomination of the candidate of another political party, no matter how pained or disgruntled the political party is with the way and manner another political party is conducting or has conducted its affairs concerning its nomination of its candidates for any position. It must keep mum and remain an onlooker, or it lacks the local standing to challenge such nomination in court, close of court. It is clear, therefore, that a political party such as the petitioner herein only has the local standing to file a pre-election matter when the situation affects it or its candidate by virtue of Section 285, Section 14C of the 1999 Constitution. That being so, as the instant petition, where the grounds of the petition is rooted on the nomination or sponsorship of the candidate of another political party, this petitioner will have no local standing, be it in the Federal High Court or an election tribunal. For that reason, it is my view that the course of action in this petition being on the nomination sponsorship of the third and fourth respondent applicant, the petition is incompetent for lack of local standing on the petition to institute the action. It is also liable to be struck out for being incompetent. The second respondent applicant also contended that the petition is not properly constituted as the candidate sponsored by the petitioner has not been joined as co-petitioner in the petition. The short answer to that is that Section 133, subsection 1B of the Electoral Act 2022 entitles a petition as a political party to institute an election petition. The applicant has not referred us to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined as a co-petitioner. It is true that it is proper for the candidate of the party to be so joined, but there is no law that compels the political party to join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal, but any non-joinder will not invalidate the petition. This is particularly so when Section 133, subsection 1 of the Electoral Act stipulates, I quote, an election petition may be presented by one or more of the following persons: A, a candidate in an election, or B, a political party which participated in the election. By the use of the disjunctive word alone or both of them. The objection on this ground is also discontinued. By another motion filed on the 15th of May, 2023, the fifth respondent, Das Kabir Masari, prayed this court to grant him the following reliefs. 1. An order of this court dismissing this petition in its entirety for one of jurisdiction. 2. An order striking the name of the fifth respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And first, other orders are this honorable court applicants. States have also considered the submissions of counsel. Section 133. Section 133 of the Electoral Act defines persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the persons whose election or return is complained of and the electoral body that conducted the election. This is Section 133, subsection 2 and 3 of the Electoral Act 2022. Those are what are termed statutory respondents. it should be remembered that election petitions are sui generis. As sui generis and is procedure restricted by statute. That's why a person does not fall within the category of statutory respondents. They are not registered parties in an election. See the cases of Agbere and Mimra, Buhari and Yusuf, APC and PDP. That's in Waziri versus Gaidam. The Supreme Court held a court. From the above, I have no difficulty in going along with the submissions of the respective counsel for the respondents. That Section 137, sub 2 and 3 of the Electoral 2020 has no room for the joinder of the fifth respondent who neither won the election nor performed any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election. And even no relief was claimed against the said fifth respondent, and indeed, he had nothing to gain or lose in the petition aforesaid. Close of court. Indeed, a holistic reading of the facts of this petition does not disclose any complaint against the fifth respondent. The only fact that relates to the fifth respondent relevant to the petition is the act of withdrawal of his candidacy as the running mate of the third respondent. That is an act that occurred within the pre-election period, therefore cannot amount to any act done by the fifth respondent at the election. It cannot therefore ground any complaint by the petitioner against the fifth respondent in an election petition. It may be relevant in a pre-election matter, but not in an election petition. It is therefore my finding that there is no any claim on the fifth respondent. Otherwise, the relief sought in the petition will not in any way affect the fifth respondent, as he did not participate in the petition either as a candidate or agent of the respondent, and no declaration was made in his favor by the first respondent. In that respect, I hold that the objection of the fifth respondent on this ground has merit. Finally, I order that the name of the fifth respondent is struck out of this petition. These are the rulings in respect of the petition number 4. I will now go to the main petition itself. So after the pre-hearing session, hearing on the petition opened and closed on the 21st of June 2023. The petitioner called one witness and closed his case. None of the respondents called any witness, but tendered some documents from the bar, and the petition was adjourned for adoption of written addresses. Parties then filed and served written addresses as directed by this court, and same were adopted on the 14th of July 2023. The matter was then adjourned for judgment. The first respondent's written address was filed on the 30th of June 2023. Therein, 4 issues were raised for determination as follows. 1, whether considering the facts of the petition and evidence laid thereon, the petitioner has the local standing to question the nomination of the first respondent as a ground of challenging the qualification and the stand of the third respondent as the winner of the presidential election 25th February 2023. 2, whether having regard to the facts pleaded and evidence in the region of Section 134 subsection 3 of the Electoral Act 2022, can the issue of validity of the nomination of the first respondent as the vice president candidate of second respondent be validly raised as a ground before this honorable court, question or challenge the qualification and return of the third respondent as the winner of the presidential election of 25th February 2023. Number 3, if the answer to not 2 is in the affirmative, whether having regard to the facts pleaded, the nomination of the first respondent as the vice president candidate of the second respondent is void as to render the respondent qualified for the election of 25th February 2023. 4, whether considering the relief sought as per the petition accrues no utilitarian benefit to the petition, not an abuse of court process. Well, to save time, all the other respondents filed briefs and raised issues. These issues have been including the issues raised by the petitioner. Now, it is apparent from the averments in the petition, the oral and documentary evidence, and the submissions of counsel that this petition is grounded on the disqualification of the third respondent to have contested the presentation of 2023. This is evident in paragraph 15 of the petition, wherein the petitioner pleaded thus. I had read it earlier. This is further explained as emanating from the non-qualification of the first respondent to have contested the election as the vice president candidate of the second respondent. It is specifically pleaded in paragraph 17 of the petition that the fourth respondent was not qualified to jointly contest with the third respondent for the presidential election held on 26 February 2023, having been purportedly nominated by the second respondent as its candidate for more than one office. The specific reasons for questioning the qualification of third respondent have been pleaded in paragraphs 16(1) and 2 of the petition as follows. Those paragraphs have been reproduced. If you get the judgment, you'll see it there. So a combined reading of paragraphs 15, 16, and 17 of the petition, coupled with the particulars thereof, show clearly that the petition is premised on non-qualification of the fourth respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in section 135, subsection 1 of the Electoral Act, that has been reproduced earlier. For the purpose of this petition, it is the ground stipulated in section 131. In other words, the election of the third and fourth respondent as president and vice president is questioned on the ground that they are not qualified to have contested the said presidential election. I consider paragraphs 18, 19, 20, 21, 22, 23, 24, 26, and 28 of the petition as relevant for termination of the petition. Which paragraphs have been reproduced in this judgment? In response, the first respondent, that's INEC, filed a reply to the petition where it was averred in paragraphs 14, 15, and 16 of the first respondent reply to the petition as follows, which have also been reproduced. The second respondent also filed a second respondent reply to the petition, also averred made their own averments in paragraph 16, 20, 21, 22, 23, 24, 25, 26, and 25, 29, which have been produced here. So from the totality of the pleadings in the petition and the replies of the respondents, what appears from the complaint of the petitioner is that the fourth respondent, while still a candidate of the second respondent for Borno's Central Senatorial District, was nominated and did accept to be the vice president candidate of the second respondent. That this act violated the provision of Section 95 of the Electoral Act 2022 as it amounted to his double nomination. That in the circumstances, his nomination as an associate of the second respondent for the presidential election is void. That the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time of the election. The petitioner relied on Section 131 and 142(1) of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of Federal Republic of Nigeria as amended stipulate as follows. A person shall be qualified for election to the office of president if A, he is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated up to at least full certificate level or its equivalent. 142(1). In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate is for election to the office of president who nominated him as such associate is duly elected as president in accordance with the provision aforesaid. The general principles of interpretation of the Constitution, which is the supreme law of the land, is that mere technical rules of interpretation of statutes are to some extent be avoided in a way as not to defeat the principles of government. That's why the words used are clear and unambiguous. A literal interpretation should be applied. In the interpretation, therefore, the provisions of the Constitution are to be accorded holistic interpretation so as to avoid ambiguity and arrive at the true intention of the legislature. The court must limit itself to the words used in the Constitution without resort to any external aid or materials. In the cases of Sani and President Federal Republic of Nigeria, Ahmadi and INEC, and Agi and PDP and others. Thus, in Wike Ezonwo Nwesom, Honorable Dr. Okuku, Adol, Peterside, and others, the Supreme Court observed that the principle of conception of the Constitution to the effect that a Constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for the present, but for the generations yet unborn. It was held that in construing the Constitution, undue regard must not be paid to merely technical rules, because in doing so, the objects of the provisions as well as the intention of the framers of the Constitution will be frustrated. Courts have always been encouraged to adopt a broad and liberal spirit in interpreting the provisions of the Constitution, while constantly bearing in mind the object which such provisions were made to close of court. That being so, where the Constitution has stipulated the qualifications to be attained by a person contesting or seeking to contest for any elective office created by the Constitution, the courts cannot create or import into the Constitution any other qualifying or disqualifying factor. This has been the position of the Supreme Court and dutifully followed by this court. It has therefore been held that qualification or disqualification of candidates to contest election is exclusively determined within the context or scope of the Constitution, and that nothing can be added to it. In other words, the Constitution being the ground norm superior to any other law, including the Electoral Act. Therefore, where the Constitution has qualified a person or candidate to contest an election, no other law except the Constitution itself can disqualify him. The petitioner in this case has premised his complaint of non-qualification or disqualification of the third respondents as the president and vice presidential candidates of the second respondent on the issue of invalid nomination of the fourth respondent. The fourth respondent, while still the senatorial candidate itself, to be nominated as the vice presidential candidate of the second respondent for the same election. Rulings earlier delivered on the motions and preliminary objections, we have ruled that the petition grounded solely on the issue of invalid nomination or improper nomination is not a cognizable ground of disqualification under the Constitution. In other words, the claim in the petition that the third respondent was not qualified to contest the presidential election because he nominated an associate whose nomination was invalid does not flow from it in section 137, 131, and 137 of the 1999 Constitution. In the cases of Aliwa and Muazu and Fati and Two versus Yoria, and in Shinkafi versus Yari, the Supreme Court held that the Supreme Court has listed in section 182, section 182 very exhaustively all the issues that can qualify a person from contesting the office of governor of a state. From the record of this court, the facts have not disclosed any evidence to show that the first respondent was not qualified to contest elections into the office of governor of Zamfara state. It is my view that once a candidate sponsored by his political party has satisfied the provisions set out in section 177 of the Constitution and is not qualified under section 182 subsection 1 thereof, he is qualified to stand election to the office of governor of a state. No other law can qualify him. This authority can apply mutatis mutandis to section 131 and 137 of the Electoral Act. It has not been contended by the petitioner that either the third or fourth respondent is trammeled by the provisions of section 131 or 137 of the 1999 Constitution. The complaint of the petitioner rooted on nomination and sponsorship of third and fourth respondent will find accommodation in a pre-election dispute which the petitioner cannot even pursue, not being a member of the second respondent. This is section 84, subsection 14 of the Electoral Act 2022 and 285, 14 of the Constitution. While I'm tempted to put an end to this petition at this stage, but realizing that this court is not the final court on the matter, I'm constrained to look at the merit of the petition. As pointed out earlier in the course of this judgment, a complaint of the petitioner in this petition is that the third respondent was at the time of the presidential election held on 25th February 2022 not qualified to contest the election. This is because, according to the petitioner, the fourth respondent was not qualified to run on a joint ticket with him, that's third respondent, as the fourth respondent nomination was invalid for double nomination, which violates section 55 of the Electoral Act 2022. As stated earlier, the petition contended that the fourth respondent was a candidate of the second respondent for the Borno Central District when the third respondent nominated him as his vice presidential candidate on the 14th July 2022. In other words, that at the time the fourth respondent was nominated, he had accepted nomination as the vice presidential candidate of the second respondent, who was still a validly nominated central candidate of the second respondent for Borno Central District. The petitioner then contended that the second respondent had earlier submitted the name of the third respondent together with that of the fifth respondent to ANIC as his presidential and vice presidential candidates for the 25th February 2023 election. However, that before the date of the election, the fifth respondent withdrew his candidature as the running mate of the third respondent on the 24th June 2023, and the name of the fourth respondent was then submitted to ANIC, that's fifth respondent, on the 15th July 2022. That the second respondent did not conduct any fresh primary election for the purpose of picking another running mate for the third respondent after the withdrawal of the fifth respondent. The respondents considered that the fourth respondent was ab initio the central candidate of second respondent for Borno Central District. However, that on the 6th July 2022, the fourth respondent via a letter dated the same date notified his political party, that second respondent, of his withdrawal from the central candidature. That upon receipt of the fourth respondent letter, the second respondent immediately notified ANIC, and which notification letter was received on the 13th July 2022. That the same letter also notified the first respondent of his intention to conduct a fresh primary election for the replacement of the first respondent following his withdrawal as a central candidate. That it was until 14th July 2022 that the first respondent was nominated as the third respondent associate for the presidential election of 25th February 2023. The fifth respondent notice of withdrawal as a candidate is in evidence as Exhibit PA2, while the notice of withdrawal and letter of voluntary withdrawal of fourth respondent are in evidence as Exhibits PA3 and PA4 respectively. It will appear that the petitioner is the view that the fourth respondent was still the central candidate of the second respondent as at the 14th of July 2022, when the fourth respondent was nominated as the vice presidential candidate of the second respondent. However, the respondents contended the issue of alleged double nomination of fourth respondent has been determined finally by the Supreme Court in People's Democratic Party, PDP versus ANIC, that in the circumstances, the said judgment of the Supreme Court constitute estoppel parem judicata and binding on the parties in this petition. Now, for a judgment to constitute issue estoppel, the conditions are earlier stated in the rulings. So the three elements must be present and coexist for a plea of estoppel parem judicata to apply. In the cases of Ito and Epe and others, Oshoboja versus Amida and others, and Alexander and others versus Lone Star Drilling Company Limited, all citation supply. It is obvious that the judgment sought to be relied on for the plea of estoppel is that of the Supreme Court, the highest and final court in this country. There is no doubt that the decision was final, and the issue that was done by the Supreme Court is the same as in the present petition, with whether the fourth respondent breached Section 35 of the Electoral Act but by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local standing of the PDP to question the nomination of the fourth respondent, the candidate of APC, a different political party. That may well be so, but it is clear from the judgment, that's Exhibit X1, that the Supreme Court pronounced on the substantive issue of double nomination. So Joro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case. The other laws of the Supreme Court proceeded to do so. It is settled law that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributory judgment contains what is not in the lead judgment will not whittle down binding effect. That's in Olu Fairba and others versus Abdurrahim. My Lord Fabi JSC said, of course, the concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements, edifies, and adds to the lead judgment when the justice adds its certain fact aspects which the writer of the lead judgment did not remember to deal with. Insofar as the concurrent judgment performs same for all the above functions, it has equal force with or as the lead judgment, insofar as the principles of stare decisis are concerned. Now, it is apparent that the parties in Exhibit X1, PDP and ANIC and other supra are not the same as in the present petition. The earlier decision, though, involved the first, second, and fourth respondents. The present petitioner was not a party in that case. That is why it was argued by the petitioner herein that Exhibit X1 cannot operate as to stop it from litigating the issue of dominant nomination of the fourth respondent. The respondents have responded that the judgment in PDP and Annex Exhibit X1 is a judgment in rem as opposed to judgment in personam. In law, a judgment in personam is a judgment against persons who are parties or privy to the particular suit or proceeding alone. It is referred to as judgment inter partes. It is a judgment binding on the parties to the action alone. A judgment in rem, on the other hand, is a judgment that determines the status of a person or thing as distinct from the particular interest of a party to the litigation. It is referred to as judgment contramundum, binding on the whole world. It is therefore binding not only on the parties to the dispute, but even non-parties. Therefore, once the status of a person or thing has been pronounced upon by a court of competent jurisdiction, no person is permitted to assert the contrary of what that court has decided. The Black's Law Dictionary, 11th edition at page 1008, Demishola versus Bolarinwa, Yanati Petrochemical Limited and EFCC. Then Ladi Jobi and others versus Oguntayo and others, additional supply. It is no doubt that the judgment matter in PDP and ANIC others X1 was in respect of the alleged double nomination of the first respondent, but the vice president candidate of the second respondent in the 25th February 2023 presidential election. That is the same issue raised in this petition as grounding the disqualification of the third and fourth respondent in this petition. Pronouncing on this issue in this case, in the contributory judgment, my Lord Okoro JSC, who presided on the panel of the Supreme Court, held as follows, I quote, "There is no doubt that the fourth respondent was at a stage nominated as a candidate representing Borno Central District, but upon being muted, he would pair with the third respondent as vice presidential candidate of second respondent, All Progressive Congress, APC, in the 25th February 2023 general election. He withdrew his candidature for the Senate before taking up the position of vice president candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July 2022, respectively, laws of court. After considering those documents, His Lordship concluded at page 7 of the control judgment that, quote, it is clear crystal clear that the two exhibits alluded to above, before the respondent did the needful by resigning his position of senatorial candidate for Borno Central Senatorial District since 6 July 2022, before being nominated by the third respondent to run alongside him as vice presidential candidate of All Progressive Congress. Close quote. My Lord Okoro went on to, after citing Section 31 of the Electoral Act 2022, held at page 8 of his contributory judgment that I quote, the above provision of the Electoral Act 2022 was duly complied with by the respondent. My well-considered opinion that as of the 6th of July, having withdrawn his nomination and personally served him on the second respondent of the withdrawal of nomination of 6 July 2022, both respondent was no longer a candidate for the Borno Central District election, and his subsequent nomination as vice presidential candidate of the second respondent for the presidential election was not multiple nomination, as there was no longer a nomination for the fourth respondent since his withdrawal on the 6th of July 2022. I have also cited the elaborate contribution of his lordship, Ajim JSC. So I have endeavored to quote extensively the of the laws of the Supreme Court in PDP and INEC Supra in order to show that the issue of double or even multiple nomination of the fourth respondent as the central candidate and vice presidential candidate of second respondent in the 25th February 2022 general election has been settled finality. It's a judgment in rem, therefore binding on the parties this petition and in fact the entire world, including this court. Being the judgment of the final court of the land, of this land, being the Supreme Court, no person is permitted to again raise and litigate on it in any other action or proceeding. It is therefore settled and remains settled that this petition, which questions the qualifications and seeks to disqualify the third and fourth respondents from contesting and occupying the seat of president and vice president of Nigeria on ground of double or multiple nomination of the first respondent and vice president candidate of the second respondent on ground of double or multiple nomination of fourth respondent has no substance. I only wish to add that Section 35 of the Electoral Act is stated at the candidate and not the political party. That is why it uses the terms candidate and normally allows himself to be nominated by more than one political party or more than one constituency. That's to prove that the candidate knowingly allows himself to be so nominated. Both the intent and actual acts of nomination, that is the mens rea and actus reus of the act prohibited, must be proved. The stipulation in the section being a penal provision. In the instant case, neither the intent nor the fact of the first respondent to allow himself to be so nominated was established. That's why his lordship of whom is JSC in his judgment. By Section 31 of the Electoral Act, the fourth respondent, Shetima, was obliged to submit a notice of withdrawal in writing to his party, which he did. And then his party is to deliver that notice to the Commission not later than 90 days to the election. In view of the above stated position of the law on this issue and the facts of this case, there exists no animus or display of intention by the fourth respondent to stand as the nominated candidate of the second respondent for the vice presidential position, and also the senator representing Borno Central District in the general election of 20 February 2023. There cannot be any other interpretation in the circumstance unless there is clear intention to knowingly stand as a candidate for two elective posts in the same election cycle. Jim JSC also contributed as follows. The manifest intention to limit earlier nomination to pave way for the nomination of another person to replace him as the party's central candidate cannot be overlooked or disregarded. To simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nomination without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies is against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the events is not what determines the existence of multiple nomination. It is the intention, design, or purpose to hold two or more nominations as candidates for election that shows that the person so nominated knowingly did so. Second respondent did not intend that the first respondent should be its candidate for Borno Central election and its vice presidential candidate for the presidential election. The first respondent did not understand or know that he was so nominated. The word knowingly in section 35 of the Electoral Act must be interpreted broadly to include all its literal meanings. Barton's Legal Thesaurus, fourth edition by William C. Barton at page 356, is defined to include advisedly, deliberately, designedly, intentionally, plannedly, pointedly, purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties in this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency, as alleged by the petitioner against the first respondent, has not been established. In other words, both the mens rea and actus reus of the act prohibited by section 35 of the Electoral Act 2022 were not established. One other aspect alleged by the petitioner on his claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate. That after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under section 29 of this act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate commission for the election concerned. The interpretation of this provision does not, in my view, cause any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to section 29 of the Electoral Act, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. But the proviso thereto, the political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the fifth respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by section 33 of the Electoral Act. It should be remembered that by section 142, subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore, in my view, the requirement to conduct a fresh primary election does not apply to the nomination of the vice presidential candidate. Thus, my Lord of GJC alerted this point in its one as follows. The fourth respondent was not required to buy any nomination form. He was the second respondent, APC's candidate at the election into the office of Senator representing Borno Central District. But before the election could hold, he was nominated as the third respondent's associate, who is to occupy the office of vice president. The fourth respondent didn't buy a nomination form for the said office, and most importantly, did not contest any primary election in order to emerge as APC's vice president candidate. The petitioner in paragraph 28(2) of his petition had averred between the period the fifth respondent expressed his intention to withdraw and his actual withdrawal of purported nomination, thereby invalidating the nomination of third respondent because the candidature of the third respondent had lapsed and was no longer in a position to constitutionally nominate a running mate. This contention of the law is conceived There is nothing in the Constitution which robs a presidential candidate of his right to nominate his associate, who shall be his running mate for the office of president. There is also nothing that invalidates the nomination of a new associate by a presidential candidate as his running mate after the withdrawal of a previous associate, so long as the nomination of new associate was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that, that the position of a person as vice presidential candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 not apply. On that note, I hereby hold that on that note, I hereby hold that the petitioner failed to prove the non-bearing of his to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason double nomination. Having resolved the sole issue of this petition against the petitioner, this petition held to be devoid of any merit.
Ẹ kú ìjókòó omi àmàlà ti fẹ́ hó mo ní lọ gbómi àmàlà lé náà bí sámàlà okay mo kí n bá yín dín ẹ̀yin tẹ́ fẹ́ àmàlà tẹ́ wà nínú oko tẹ́ fẹ́ gbọ́n tó ń ṣẹlẹ̀ lénìí tẹ́ fẹ́ gbọ́n tó ń ṣẹlẹ̀ lénìí ẹ̀yin táwa tá jọ́ mọ́ oko màá bá yín gbómi àmàlà lé náà bóyá kí n bá yín ro àmàlà tewédú àti pẹ̀lú ẹ̀yin tẹ́ jọ́ mọ́ gbòòrò mo ti bá yín wá omi tí mo ti gbé lé náà yín bá yín po mílò sí yín bá yín fi mílìkì bíntín sí lórí yín bá yín fi búrẹ́dì slice ẹyọ kan oúnjẹ àárọ̀ ti tó ẹ̀yin tí ẹ dẹ̀ wò pé ẹ lè jẹ kankan nú ẹ̀ àǹfààní wà kọfí wà nílẹ̀ àtomi ṣẹgbọ́n ẹ kú jókòó ẹ jẹ́ kí n sáré bá yín lọ prepare sí a ní wá kí yín ní o.
Well, we'll rise for just 15 minutes and continue with petition number 3 and 5. I can see Dr. Levy moving up and down. So, as an elderly person, I know what is going on.
Lord, we just wondering, your brethren, I said, we're just wondering.
So it's a consolidated judgment. They will their contributions after we have read all the judgments.
My lords, please. We just needed to know, sir.
Yes, all they will give their.
Thank you very much, my lord. Thank you, sir.
All the court.
Well, so far.
First part. Well, we can't tell at this time if it's the first part, but first part of the proceedings has just gone underway.
Well, what the justice said was that's the fourth item, so to speak. So there's still the third one, there's second and the first. But the reason that they're together is according to the justice. They are consolidated. In other words, they are all related one way or the other. You'll see that a number of times he would say, look, as we had previously mentioned, it's a pre-election matter. Previously mentioned, it's a pre-election matter. But at least one thing can be said clearly, that the court has struck out APA suits against Shettima and Tinubu for lack of merit. For the preliminary objection, the court held that the petitioner, that's APM, ought to have filed the case before the Federal High Court within 14 days from the course of action, from the day of the course of action arose. The court agreed with the respondent that the issue is statute barred. And consequently, the justice who read the leaked judgment added that Section 285 sub 14C does not allow members of any political party to challenge the nomination of candidates of another political party, and consequently declared that the petitioner lacks the local standing to institute the petition.
And recall that the PDP did indeed take the matter to court as a pre-election matter, and the Supreme Court held that there was no double nomination. So on this case, the petition, the judge has ruled that the petitioner failed to prove that the third and fourth respondent failed to prove that they were not validly nominated. And on that strength, it's been struck out for lacking in merit.
It's a long haul. We're still, this is pretty much, as we have been informed, the long haul.
The long haul means by implication.
Yeah.
We could be here for another 2 to 3 hours, so to speak. But, in response to one of the council's inquiry just moments ago, Justice Samani may have said that, it's a contributory judgment. I wonder what's the implication of that. Is it that it's a contributory judgment from all of the other 4 justices, or will there be a dissenting judgment?
Well, I guess that's what we would wait to see, because, if you recall what Mr. Kwek has told us the other time, as well as Dr. Titoju in Abuja, that look, a lead judgment could take X number of hours. And if you also recall what the justice said to us, this is just the judgment. There are other arguments in it. You have to get it later. I'm like, okay, so this whole conversation started sometime around 10 o'clock?
9:27 to be precise. I took note of the exact time that the judges walked in. But, just also warn you that Senior Advocate Morrison also said that in case there's a dissenting judgment, that could also take some time. Yes, yeah.
So there is contributory judgment, there is dissenting judgment.
We do not know for sure.
I don't know. That's why maybe I should ask senior journalist of Nigeria and senior advocate of journalism, but
no,
that's Chamberlain and Sheon, because they went to town on the case the other time as well. But I guess we'll wait to see the very appropriate time. The court is taking a bit of
a break,
leg stretching break. The justice said 15 minutes, and he said, going by the ages of the people informed, yes, he knew what it meant.
Justice Samani indeed noted jocularly, that Mr. Uzoku, senior advocate of Nigeria, was up and about due to age. So it was just a good time to take a break.
Well, and that's actually humane. The fact that we have work to do does not mean that we shouldn't be sensitive to the issues. So I guess that's 1 down, 3 to go so far.
You were talking about senior advocate of journalism. The senior advocate of journalism in Abuja was telling us earlier that there are 3 main hinges upon which the judges always rule. The strength of the case, that's the strength of the argument, the facts of the matter, and evidence, tendered before the court. And we're seeing that play out in the first, of the many items before the court today.
See why I called him senior advocate in journalism?
Yeah.
Okay. So we'll take a short break in a moment or two, just to let you know that in a moment from now, we will continue with our broadcast of this. And as we mentioned to you, we've been trying. Oh, by the way, we could also inform you that not a few issues are trending right now on X about this particular case. Number one, the PEPT judgment is the number 1 hashtag right now. 25% in FCT is also trending. Justice Samani earlier trended, I think, number 3, but now is trending quite down the ladder, at least about number 9 or so right now. And a number of other trends. Presidential Tribunal is also trending, and several others like that. So just so we know.
And also to inform you that during the first part of the proceeding, just before the break, we had more than 24,000 views.
More than 46,000 on our dedicated stream. But we have others all numbering up to about between 4,000 and 5,000 on X watching this live broadcast.
And I believe senior advocate of journalism on the other end in Abuja, Nyota, wants to weigh in on the matter. Nyota, are you there now?
Well, I'm not sure that he is, but let's see. Most certainly when he is, he will most certainly be brought in to have a conversation with us on the matter. So we need to take a little bit of break in a moment or two, but just to let you also know that the court, the Presidential Election Petition Court, has declared that as at this moment, APM suit against the Vice President Shettima and President Tinubu has been struck out for lack of merit. The critical case made was that, look, this is supposed to be a pre-election matter and consequently should have been dealt with within 14 days from the day the course of action arose.
Actually, Ayo, we surpassed the 46,000 mark. I think that was the last time we checked. The update now is that we hit 70,000 views.
Oh, wow.
At the peak of the proceeding, the reading out of the judge's ruling by Justice Haruna Samani.
See?
Yeah, 70,000. And we're bound to surpass that when there's a resumption of the continuation of proceedings, when the judges begin to read the ruling from the other petitions.
But at this moment, maybe because of the break, we've come down to 59,000 as we speak. And that's just for one of our views. As we mentioned to you earlier, we have 2 other streams that are doing about the same thing. So, well, as I'm being corrected now, someone is saying that the journalistic equivalence of SAN is SAP, Senior Advocate of the Pen. Well, I guess we'll come back to that some other time. So we can take a short break, and we'll be right back with you to take on more of that. Don't forget, so far, the decision of the court remains the APM suit against the president and the vice president has been struck out for lack of merit, and the court has said it's something that should have happened at least 14 days within the time it happened and the cause of action that should have arisen. We'll be right back.
ẹ̀yin èèyàn mi, ẹ jẹ́ ká máa gbéra wa lẹ́nu jó lọ kán tó get back. Mo fẹ́ bi wá ní ìbéèrè kan torí mo kọ ìbéèrè yẹn síbẹ̀ yẹn, but mo rí pé most of people, àwọn èèyàn kan sọ fún mi pé irú ìdájọ́ wo ni mo fẹ́ kí wọ́n ṣe. Ẹni ìdájọ́ tí wọ́n bá ti ṣe ni àwọn náà wà níbi ìtẹ́ ìdájọ́, kì í ṣe mi. Ṣé you understand? Àwọn náà wà ní ìtẹ́ ìdájọ́, mi ò sí ní position láti yọ anybody. I am not in position to remove anybody. Jẹ́ kí n gbọ́ nǹkan tọ́lọ́pàá ìsọ̀ ń bọ̀.
Leaders, including mischief makers,
ẹ jẹ́ àgbọn tí ń wí.
to be cautious in their actions and statements as the force will not condone activities capable of inciting violence or causing a descent into anarchy. It is imperative for all citizens to embrace peace and maintain calm, regardless of their political affiliations, to ensure a peaceful and secure environment.
Accosted ni wọ́n mú. Now, mo fẹ́ kí èèyàn mi ṣe rí wípé nínú ọ̀rọ̀ tí wọ́n sọ nínú àwọn ọ̀rọ̀ yẹn, ṣe mọ̀ pé mo mọ̀ pé tí n bá sọ̀rọ̀ yẹn ọ̀pọ̀lọpọ̀ á máa ṣẹnu wọ́yọ̀wọ̀yọ̀. Ọ̀pọ̀lọpọ̀ á ṣẹnu wọ́yọ̀wọ̀yọ̀ sí mi láàárọ̀ yìí, but èmi ò rán yín sẹ́, but I will still say the truth. Ṣé ẹ mọ̀ pé nínú àwọn nǹkan tí wọ́n mú jáde ní kóòtù yẹn, MC Olúọmọ ń tó ṣẹlẹ̀ lÉkòó, èmi ò sí níbi tán ti ń ga sẹ́yìn rọ o, kò sí ní tó kàn mọ́ bá jọmọ ìyá mi màá lé òní kò lórí. Ṣé ẹ mọ̀ pé nǹkan tí MC Olúọmọ ṣe pẹ̀lú gbogbo threatening ní public, gbogbo threatening ní public Yomi mo rí ẹ, gbogbo threatening yẹn, ṣé ẹ mọ̀ pé èèyàn náà wà lára tí wọ́n fi ń judge Tinubu sí. Gbogbo bẹ́ẹ̀ ṣe lu ọmọ ọlọ́mọ lálùjá lójú l'Ékòó, tẹ́ rò pé nìkan lẹ níjọba tẹ́ ń hùwà gbèrò. Ṣé nígbà tẹ́ débẹ̀ tó nìsín, ṣé Tinubu yẹn, ṣé wọ́n ń gbúrò yín bọ́ ṣe ń gbúrò yín tẹ́lẹ̀? Gbà tí Tinubu wà l'Ékòó lẹ́ ń hó. Tẹ́ bọ́ sí public tẹ́ ń threaten life àwọn èèyàn. Kì í ṣẹ̀yìn náà o, Àtàsárì Dòkunbọ̀ tó náà ń threaten àwọn ará ọ̀dọ̀ títí ẹ̀ lọ́n, but kì í ṣègbè election ló ń threaten, after election nìyẹn. But tí MC Olúọmọ ṣe l'Ékòó, torí ẹ máa sọ pé àwọn Yorùbá nation kan, Yorùbá nation support, Yorùbá nation kan ṣe lọ́wọ́ ẹ̀ ó support yín, èmi fi gbogbo ẹnu sọ, mo ní proof ẹ̀, wọ́n support yín. Ẹ̀yin tẹ́ ẹ lẹ́ support Tinubu gangan, tẹ́ ẹ jẹ́ full loaded Tinubu, ẹ̀yin gangan ni ọ̀dádá, tí wọ́n bá ṣe ìdájọ́ yẹn lénìí, kátẹ̀wá náà ṣe ìdájọ́ mo ń sọ o, tí wọ́n ṣe ìdájọ́ wípé tí wọ́n bá ṣe ìdájọ́ wípé torí ohun tó ṣẹlẹ̀, torí ni wọ́n mú wá fún yín, wọn ò ní sọ pé àwọn èèyàn ẹ̀yin gangan ni ọ̀dádá tí ń pọnmọ́ re balùwẹ̀. Ṣé rí ẹ̀yin ẹ̀dá kan tẹ́ ẹ bá ti wà níbi yóò dáa fún yín. Esther jẹ́ sáré gbé ògì kan sẹ́nu. Mo ní ìmọ̀ ògì láàárọ̀ ẹni, ẹ má bínú ògì òyìnbó. Custard ló ń jẹ́ bẹ́ẹ̀, mi lè wá kú. Torí pé mo lè jí lẹ́ni pé mo fẹ́ gbé ròyìn, gbogbo inú sì ń ta mí fo. Now, ẹ̀yin èèyàn mi, ṣé mo parọ́? Ṣé rí ó dìgbà tí ẹ̀yin èèyàn mi já mi ẹ̀lẹ́ Tèmiládé mo rí yín mà. Ṣé rí ó dìgbà tẹ́yin èèyàn bá tó mọ̀ wípé freedom of expression wà, freedom of speech ó wà. Kò sí tí ènìyàn bá wà nínú ayé ẹ lè sọ wípé ẹ̀yin nìkan ni kí gbogbo ayé dìbò fún. Kò possible. Oníkálùkù ló ní entitled sí opinion tiẹ̀. Orílẹ̀-èdè lẹ́wà níbi tí orílẹ̀-èdè tẹ̀dẹ̀ wà ní ẹ ṣe orílẹ̀-èdè ẹyọ kan. Ẹ má gbàgbé o. Nigeria is not a one nation. Nigeria state. Nigeria is not a one nation. We have different tribes in Nigeria, but we have 4 regions. We have 4 regions. We have Western region, Western, Eastern, East, Southwest, and Southwest, and South, Southeast, North. Ẹ mọ̀ gbàgbé pé àwọn middle belt, àwọn Igbo ọ̀tọ̀ ní state ní ilẹ̀ wọn. They are different. We can be a one Nigeria. Mẹ́rin ni wá. Southeast, East, North, West àti South. Àwọn middle belt ìyẹn Niger Delta. Àwọn Igbo Biafra ẹ̀dẹ̀ ní ilẹ̀ Haúsá. Ẹni Haúsá kò sí tí ń jẹ́ Fúlàní, Haúsá ni. Ẹni Haúsá bó tilẹ̀ pé Fúlàní ti pa, ó ti gbórí, ó ti gbogbo Haúsá, wọ́n ti lẹ orí wọn mọ́ gànà bì kan. So àwọn náà ń lo orúkọ lọ yín òkè wá. North ni gbogbo wọn papọ̀. Now, ẹ̀yin èèyàn mi, bí ẹ̀yin ṣe wá rí yẹn, kẹ́ wá ní èèyàn kan wá jáde ní country kan, ẹ mọ̀ wẹ̀ pé different country ni wá. Yorùbá is another country, Igbo another one, North, ìyẹn àwọn Arẹwà another country ni wọ́n. Àwọn Igbo another country ni wọ́n, Middle Belt another country ni. Kẹ́ wá máa dúró nídúró wípé èèyàn kan jáde nílẹ̀ Yorùbá. Kẹ́ wá ní kí Igbo, Haúsá, Yorùbá, Middle Belt, kẹ́ wá ní kí gbogbo wa support ẹni tó jáde nílẹ̀ Yorùbá. Kó má ṣe ẹni tó máa castigate, kò lè possible. Kẹ́ ní kéèyàn kan jáde nílẹ̀ Igbo, kó mọ̀ wá sí Yorùbá tí ò ní no, mi ò fọwọ́ sí. Kó mọ̀ sí Haúsá, kó mọ̀ sí àwọn East, Middle Belt, pé no, ẹni yìí a fọwọ́ sí. Kẹ́ wá fọkàn sí pé gbogbo wọn á dẹ̀ dálé lẹ́yìn. Ìyẹn mi pé ẹ̀ nítumọ̀ nù. Ìyẹn mi pé tó ń ṣẹlẹ̀ ní àwọn ìlú táwọn ghost ti ń, àwọn kọlù ti ń rúlu wọn. Bí Gabon. Téèyàn kan ti wà bẹ́ẹ̀ láti 1984 tí ìbá ṣe ṣe ayé. Láti 1984 kéèyàn kan sì máa rú tó dẹ̀ ti ń gbọ̀n báyìí. Tọwọ́tọwọ́ ló ń gbọ̀n. Láti 1960, 55 years ni bàbá ẹ̀ kọ́kọ́ lò. Bàbá kúrò bẹ́ẹ̀ after 55 years. Ọmọ gbà ní 1984. Láti 1984, orú di 2009. Láti 2009, èèyàn kan tó wà bẹ́ẹ̀ dì sí. 40 years, eléyìí tó wà bẹ́ẹ̀ ni ò tún fẹ́ kúrò. Ó tún wá lọ ṣe torí pé kò fẹ́ kí oyè yẹn kó kúrò nínú ìdílé wọn. Ó ti sọ di oyè ẹbí. Ó wá lọ ṣe kúrùkù yẹn torí ó mọ̀ wípé ghost lòun. Wọ́n lè gbá òun yọ láti any fucking time. Now, wọ́n wá lọ ṣe kúrùkù yẹn mọ́ cousin. Bí bóyá bí ọmọ ìyá ni o, bóyá ọmọ bàbá rẹ̀ ni o, bóyá àbúrò ni o, bóyá ọmọ ẹ̀gbọ́n rẹ̀ ni o, bóyá family member ni o, ṣùgbọ́n cousin la pè é tó sọ ọmọ ọkùnrin. Ó wá lọ pàdé àpòpọ̀ mọ́. Ó ní pé kó gbàjọba yẹn sódà àtijọba yẹn á lè wà nínú ẹbí wọn. Ìkan náà wà ní mo ti máa padà wo orúkọ yẹn. Tẹ́ bá rí máàní tá a sọ ẹ̀, ṣé bẹ́ẹ̀ ní Tinubu, ṣé bẹ́ẹ̀ jẹ́ lọ́wọ́ nìkan. Àti Tinubu sì rìn. Ẹ má jàgbẹ́, Tinubu sì rìn. Ọlọ́run, àlélẹ̀ wheelchair náà fi ń ti bàbá eléyìí tẹ́mi sọ ẹ̀. Wọn kò lè dá dúró. Ó ń gbọ̀n ni lẹ́ni tó ń gbẹ dákun. Ṣé wọ́n fẹ́ sọ fún mi pé nìyẹn ló ń rù lùlù? Ọwọ́ rẹ̀ gángbọ̀n, kò rọwọ́ kan fi kàn kankan mọ́. Ẹnu rẹ̀ ti wọ́, ẹsẹ̀ ti wọ́, kò lè rìn mọ́. Ẹ wá lòun ló wà lórí ipò. Ẹ ti mọ̀ pé àwọn òyìnbó amúnisìn yìí, ọmọ wọn ni wọ́n wà ń bẹ̀ tán rúlu lọ. Àwọn ọmọ wọn náà ń rúlu lọ, kì í sáwọn gangan. Now, kẹ́ wá ní kẹ́nìbọ̀dì má castigate àbí kó má instigate àbí kó má sọ̀rọ̀ nípa Bọ́lá Ahmed Tinubu. Kẹ́yìn wá fọkàn sí pé rárá o, torí pé ọmọ ẹni ìṣèdí bẹ́ẹ̀ bẹ̀rẹ̀ o, kàbí síjọ mẹ́lòmí o everybody gbọ́dọ̀ support Tinubu kálí Tinubu help ebi tó bá fún wọn lóúnjẹ sófè mi lóúnjẹ òní nìsín wo ògì ni mò ń mu láàárọ̀ yìí mo ti gbàgbé ẹyin mi ń bọ̀ torí ń jẹyin kí n lè yasó dáadáa kẹ wá sọ fún mi wípé kò ní sí anybody tó máa sọ fún Tinubu pé kò ṣeé ṣe ṣe bí wọ́n bá ń jẹ lábẹ́ Tinubu ṣèmi ń jẹ lábẹ́ Tinubu tí wọ́n bá ń jẹ lábẹ́ Òbí ṣèmi ń jẹ lábẹ́ Òbí t'Àtíkù bá ń bọ́ ẹ ṣèmi náà ń bọ́ ni tẹ́ fi ní kí n sọ́pọ́ọ̀tì ẹlòmíì mi ò jẹ lábẹ́ Tinubu mi ò jẹ lábẹ́ Òbí mi ò jẹ lábẹ́ Àtíkù èmi wà ní tra ni pé ẹni tó bá máa ṣe tó dáa fún yín tó òfin ní máa tọrọ bárà ká mọ́ tẹ́ ẹ̀ ní bímọ kẹ́ lọ máa sọmọ sínú igbó tẹ́ ẹ̀ ní bímọ tẹ́ lọ máa sọmọ sínú jù tí ò ní sí pé yà ń dín bàbá fọmọ sọwọ́ ẹ wo iye èèyàn tí wọ́n ti yọ ẹ̀mí ẹ̀ dànù ní Ògùn state ẹ wo iye àwọn tán ti pa níbi ògùn owó tán náà ń ṣe kiri lógùn state bàbá ń pa ọmọ ń pa bàbá ìkan la tún gbọ́ tó mú bàbá rẹ̀ tó sá wẹ́lẹ́wẹ́lẹ́ Olúwa yẹ Ògì sí mímọ́ ó mú bàbá ẹ̀ ó sá wẹ́lẹ́wẹ́lẹ́ ó sá jákàjàká bá ń tẹ lọ́ọ̀fù yóò dáa fún ọ bá ń tẹ lọ́ọ̀fù ayé rí òní pinyìnkì bá ń tẹ lọ́ọ̀fù yóò yí ọ orílẹ̀-èdè tá a wà ẹ̀ ká ní freedom of speech gbogbo nǹkan lẹ́ẹ̀ma ẹni bá sòótọ́ ẹ lò rude mo mọ tẹ́ fojú tẹ́ ní ọmọ ológo lórí Tinubu o lórí pé mò ń bá yín wí pé ẹ má bú àwọn èèyàn ẹ jẹ́ kó ní kálukú ní freedom láti lè sọ̀rọ̀ ẹ̀yin tí Tinubu fún lóúnjẹ tó fi yín síbi iṣẹ́ tàbí tẹ́ ẹ ti pàṣẹ àwọn ọmọ tó fi síbi iṣẹ́ ríṣẹ́ ẹ̀yin mi wò lè ṣe pàṣẹ àwọn tó fún lóúnjẹ lẹ fi ríṣẹ́ bóyá bí àwọn gómìnà tó jẹ́ pé ló jẹ́ wọlé ìnìwọ́ ti ń jẹ lẹ́yìn agbèrò kan ti ń jẹ yín tọ́ọ̀gì kan ti ń jẹ àbẹ́yìn kan ṣe ọmọ onílẹ̀ torí pé ẹ ti láṣẹ ń bẹ̀ wọ́n lè mú yín àbẹ́yìn kan jẹun nílé òrò jẹ nílé egúngún bẹ́ẹ̀ bá gbà lọ́wọ́ Tinubu ẹ gbà lọ́wọ́ Àtíkù ẹ gbà lọ́wọ́ Òbí ìwọ tí wọ́n láǹfààní láti máa jẹ nílé òrò jẹ nílé egúngún èmi tí sì láǹfààní àti jẹ nílé rẹ̀ jẹ nílé egúngún ẹ bá lẹ́sẹ̀ ní fẹ́mi ṣé gbogbo èèyàn ẹ rí bí yàṣẹ di àwọn èèyàn ọ̀rẹ́ ti brainwash ọ̀pọ̀lọpọ̀ àwọn orí débi pé most of people gan sọ ọ̀dẹ̀ wo ló ń kọ̀ mí ní fídíò kọ̀ bẹ́ẹ̀ kí n ṣépè fún yín ni ẹ má máa pè mí ní fídíò kọ̀ mọ́ o ẹ ṣọ́ra yín o ẹ má yẹ kí n bá yín jà o ẹ dẹ́ máa pè mí ní fídíò ẹ fa gbogbo òṣì yẹn tí mo bá ń bá yín ṣeré níta yín omi pé mo useless o I'm a responsible woman woman yóò dà fẹ́ yìí tèmi mo yà só díẹ̀ now torí pé yẹn dẹ̀ ti ṣẹlẹ̀ yẹn ẹ wo tẹ́ ẹ ṣe nínú election ẹ wá tilẹ̀kùn tilẹ̀ ní ìfẹ́ ẹ̀ ló kí lẹ fẹ́ o ẹ̀ ló ẹ káàárọ̀ o yes à ń gbọ́ ok kí ni mo lè ṣe fún yín o ẹ ṣeun gan ni thank you ẹ má pè mí fídíò kọ̀ mọ́ o
ẹ má bínú mo ṣe change ẹ sí audio.
ẹ ṣeun
sorry
a ti gbọ́ ẹ̀yin náà ṣeun thank you
good to hear from you.
you are welcome thank you sir all right ẹ má bínú ẹ̀yin èèyàn wá bí mo ṣe bọ́rọ̀ mi lọ wọ́n tilẹ̀kùn máwọn èèyàn kan lórí wọ́n ní àwọn ò ní gbà káwọn èèyàn jáde wọ́n wá ń dá ìbò dì sẹ́mi ò sọ fún pé gbogbo tẹ̀sí yóò lẹ́yìn ìjọ kan kódà kan tẹ̀ wá padà fi Tinubu síbẹ̀ gbogbo àgbáyé ti rí i pé wà tẹ̀ wò tọ́ eléyìí tí wọ́n dá fún yín nísìn wípé ẹ ṣe báyìí ṣẹ́yìn náà ti rí kódà kan bá padà gbé fún Tinubu pẹ̀lú àwọn èèyàn ò ní gbà torí wọ́n á sọ pé wọ́n ti rí òótọ́ pẹ̀ẹ́dẹ̀bí ṣùgbọ́n wọn fẹ́ sọ fún ọ̀sọ̀tọ́ mo máa ń sọ fún yín pé má máa lo agbára lọ́wọ́ ara yín tí wọ́n bá nífẹ̀ẹ́ táyé má sọ pé mi náà máa nífẹ̀ẹ́ táyé ìdí tó Ọlọ́run dá ilé ayé yìí kò dá dọ́gba ẹ̀yin fẹ́ jẹ́ pí Ọlọ́run tẹ́fẹ́ máa gbèjọ́ Ọlọ́run tó dá ìka ọwọ́ wa ó dá wípé òun ò fẹ́ kó dọ́gba ó ó yẹ kẹ́ ẹ ti rí òye Ọlọ́run àti àpẹẹrẹ Ọlọ́run dá ẹgbẹ́ nídà wípé ó dúdú olórí èèyàn pupa ó dá èèyàn funfun ó dá bọ̀rọ̀ kìnní ó dá láwọ̀ kàlánkìnní ó dá dúdú bíi kórósín ó dá dúdú bíi èédú ó dá gold ó dá èèyàn tó jẹ́ pé skin rẹ̀ bíi gold ni ó dá èèyàn tó jẹ́ pé chocolate colour ni ìyẹn brown leather wood ó dá ó dẹ̀ dé èèyàn tó jẹ́ pé ó ra mọ́ lólóló ó dá àràrá ó tún wá dá eléyìí tí tó ń saràrá tó pọwọ́lé ó tún wá dá ẹni tó ṣe bàǹbà bẹ́rẹ̀kẹ́tẹ́ ó dé èèyàn tó jẹ́ pé bàǹbà báyìí ni ojú ọ̀nà inú ilé mi yóò bá gbà báyìí wọ́n fún mọ́ bẹ́ẹ̀ ni wọ́n bíire kó ló fẹ́ irú living room mi nìkan ni ó mọ dúró sí kò lè tó wọ́n bíire kó ló fẹ́ wọnú yàrá ìwà torí yóò fa ojú ọ̀nà ya ni bí bẹ́ẹ̀ kọ́ wọ́n yóò wá àwọn kan tí ó mọ púṣẹ̀ báyìí kó tó lè wí ibi wọlé ni ojú ọ̀nà ló dàbí báńkó náà ojú ọ̀nà inú ilé tí ó mọ̀ lò bí báńkó ni mi ní òwà fẹ́ pé ẹ mọ̀ sídọ̀ rẹ̀ ẹ mọ̀ sí báyìí bí ilẹ̀kùn ṣọ́ọ̀ṣì ni ojú ọ̀nà inú ilé wọn ṣe rí àmọ̀ fi yọ wọn àmọ̀ fi ń gbórúkọ lọ́gà irú àwọn yẹn wọ́n wà ń bẹ́ o bẹ́ẹ̀ Ọlọ́run wá dáwọn nǹkan tó tún pọwọ́lé ó tún dáwọn nǹkan tó tún pọwọ́lé tó tún tóbi díẹ̀ ó tún wá dáwọn tó tún pọwọ́lé ó tún dáwọn tó tún pọwọ́lé ó tún dárú àwa yìí bọ́lá ń ṣe tó ìdí ńlá bàǹbà ṣùgbọ́n tí gbogbo ara rẹ̀ ti rín látòkè ó ti rín dókè ni ṣùgbọ́n ìsàlẹ̀ yìí tóbi sí abọ́ àti ìtàn pàǹpà báyìí ni ẹlòmíì wà kò ní ìdí Ọlọ́run ni ó dá ìtàn lásán ẹlòmíì ìtàn lásán ló fi ṣe ìtàn ó dàbí àpótí fẹ̀dẹ́kò ni bẹ́ẹ̀ lẹ́lòmíì dẹ̀ ni kò dẹ̀ ní ìdí bẹ́ẹ̀ ló dá ẹni tó ní ọyàn gbàǹgbà ó yẹ kẹ́ ẹ rí Ọlọ́run lára ènìyàn ṣebẹ́ lọ́lọ́run ò sí ṣebẹ́ yìí lẹ́yìn fẹ́ bọ́lọ́run jà torí ẹ fẹ́ kọ́lọ́run ṣe déédé ẹ̀yin fẹ́ kọ́lọ́run ṣe déédé kó jẹ́ pé èèyàn kan ń tẹ́yìn bá ti fẹ́ yẹn ń ní kẹ́lómi náà mọ̀ bá yín fẹ́ ẹ jẹ́ ká sáré gbọ́ news bóyá ti ń káròyìn lọ.
àná vague nebulous.
ẹ jẹ́ ká gbọ́ròyìn o ẹ jẹ́ ká máa gbọ́ròyìn lọ bóyá nẹ́tíwọ́ọ̀kì wọn nẹ́tíwọ́ọ̀kì channel nẹ́tíwọ́ọ̀kì o wọ́n ti ń káròyìn lọ jẹ́ máa sọ̀rọ̀ lọ kí nẹ́tíwọ́ọ̀kì wọn tó dé padà. now ó dá láwọ̀ ọ̀bọ̀rọ̀ kìíní ó dá ẹni tó ní ọyàn rẹ̀ gbàdì bẹ́ẹ̀ ló dá ẹni tó ní ọyàn kékeré ó dá ẹni tó ní ọyàn títí ní ó dá ẹlòmíì kò ní ọyàn rárá ẹlòmíì ò ní ọyàn rárá ó dá ẹni tó ní ọyàn pàǹdọ̀rọ̀ ó dá ọlọ́yàn rogodo ó dá ohun kálukú onídìí òro ẹlòmíì ìdí òsè ẹlòmíì ìdí àràbà bẹ́ẹ̀ ni ìdí àgbálùmọ̀ lóríṣiríṣi lọ́lọ́run dá ìwọ sì fẹ́ ọ̀sìn fẹ́ kọ́lọ́run ṣe déédé Ọlọ́run ò ṣe déédé tó bá fẹ́ ṣe déédé á dá everybody bákan náà òun tó lè dá òyìnbó aláwọ̀ funfun tó tún wá mú kàlákìnní sí jọ́sẹ̀ wọ ni Ọlọ́run kò tí wáyé kó mọ̀ wípé Ọlọ́run ò ṣe é gbèjà lọ ń wò yẹn Ọlọ́run ò ṣe é gbèjà ṣé wọ́n lè gbèjà Ọlọ́run ni o ò lè fight fún Ọlọ́run ọmọ àǹtí mi ìwọ dẹ̀ ṣé ìwọ gan tó wà ẹ̀yin tẹ́ ẹ wà ní Nàìjíríà yẹn tẹ́ ẹ níyàwó méjì mẹ́ta ṣé ẹ ṣe déédéé láàrin àwọn mẹ́tẹ̀ẹ̀ta just answer my question ṣé ẹ ṣe déédéé láàrin àwọn ìyàwó yín mẹ́tẹ̀ẹ̀ta ẹ lè ṣe déédéé kódà tẹ́ ẹ bá bí ọmọ ǹjẹ́ ẹ lè ṣe déédéé láàrin àwọn ọmọ yín bí ẹ lè ṣe déédéé láàrin wọn ẹ lè ṣe déédéé láàrin àwọn ọmọ yín gan pẹ̀lú ọmọ àǹtí mi ìwọ gbọ́ ò lè rí déédéé ṣe ìwọ tó ò lè ṣe déédéé láàrin àwọn ọmọ tó o bí ẹ máa ń fi kan kẹ́kan ẹ lè ṣe déédéé láàrin àwọn ìyàwó yín ẹ máa ń fi kan kẹ́kan ẹ nífẹ̀ẹ́ kan jù kan lọ bẹ́ẹ̀ bá lọ́rẹ̀ẹ́ ẹ nìkan jù kan lọ bẹ́ẹ̀ bá ní èèyàn lásán ẹ tún ṣe àbòsí kí ẹ ṣe èké lẹ́yìn ẹ ṣe àbòsí ẹ ṣe èké lẹ́yìn kò sí bẹ́ẹ̀ ṣe lẹ́ẹ̀ nífẹ̀ẹ́ nìyẹn tó ẹ sì máa ṣàbòsí ẹnìyẹn sáà ni ẹ sì máa rí mistake ẹnìyẹn sáà ni ẹ sì máa rí wípé ó ṣe kiri kan sáà ni kò sí. Tẹ́ ẹ bá ní àkòsí tí lágbájá lè ṣe tí mo lè bínú sí because ìjọ tẹ́ ẹ bá ṣe tẹ́ ẹ bá rí kápá ẹ rọ̀jú ọ̀sọ̀ sáà lórí ẹnìyẹn sáà ni. Ẹ rí mistake ẹ̀ ìyẹn mi pé ẹ lè ṣe déédé. Ọlọ́run nìkan ló lè ṣe déédé. Déédé tó lọ́run dẹ̀ lè ṣe fún yín kó má bàa dìjà. Lọ́lọ́run ò ṣe jẹ́ kó jẹ́ pé èèyàn kan ṣoṣo ń ló dá èèyàn burúkú èèyàn kúkúrú. Kì í ṣe èèyàn kan ṣoṣo ń ló dá fún èèyàn pupa. Ó dé èèyàn pupa tó pọ̀ jágburu. Ó dé èèyàn dúdú tó pọ̀ dáadáa. Ó dá funfun. Ó dá oríṣiríṣi ènìyàn ni Ọlọ́run dá kó má bàa dìjà ni. Torí tó bá dé èèyàn tó ga ẹyọ kan ṣoṣo, àwọn míì wà tán ga bí àgalì. Àwọn kan wà tí wọ́n dàbí àgéré ẹlẹ́sẹ̀ méjì. Àwọn kan wà àgòrò. Àwọn kan wà bí irú tiwa báyìí. Àwọn kan wà tá pè wá ní giants tó yẹ pé asígbọnlẹ̀ ni. Ó ga látòkè bẹ́ẹ̀ ó dẹ̀ sígbọnlẹ̀ bẹ́ẹ̀. Ó straight pàdé. Bẹ́ẹ̀ ló dé lómi tó ga tó tún wá ṣe bàǹbà. So ẹ má bá Ọlọ́run rojọ́. Ọlọ́run tó ń sọ̀rọ̀ ó mọ ohun tó ń ṣe. Ṣùgbọ́n ẹ̀yin ẹ sáà fẹ́ gbọ́n jọ Ọlọ́run lọ. Ẹ fẹ́ gbèjọ Ọlọ́run. Bọ́lọ́run bá fẹ́ ṣe tó dáa, adẹ́lẹ́sìn ẹ̀yọ̀ kan ṣoṣo. Adẹ́ni tó jẹ́ pé ẹ̀sìn kan ṣoṣo ló ń ṣe. Thank you o. You are really trying. God is our creator. Bẹ́ẹ̀ ni o. Thank you. Thank you o. Ọlọ́run bá fẹ́ ṣe kò wulẹ̀ níbà ń rojọ́. Ọlọ́run ń rojọ́ wẹ́wẹ́. Èèyàn ló máa ń rojọ́ wólowòlo. Olódùmarè ò sí nínú ẹni tó máa ń báyàn rojọ́ jákujàku. Níbo ló ń wà? Bó ló tẹ́lẹ̀ ń jọba níwájú ọba payányán. Ọlọ́run ò sí níwájú ọba apànìyàn tó máa rojọ́ wúluwúlu. Òun lọba tó lè pani. Òun náà dẹ̀ ló lè jí ènìyàn. Kò sẹ́ni kankan tó lè jí ènìyàn nílé ayé yìí. Ẹni tó bá lòun jí ènìyàn gbà wípé ẹ̀mí ẹni yìí ò tí ì lọ. Ó ṣeé ṣe kó ṣe wípé ṣe ló dákú. Bóyá ènìyàn dákú, ó wá lo pẹ̀sẹ̀ nìyẹn láti lè lo àwọn nǹkan kan fún láti lè dá padà. Èèyàn máa ń wà ní kómà. Kómà nìyẹn, kómà olóyìnbó. Kómà olóyìnbó lẹ́lòmíì máa ń wà. So kómà olóyìnbó yẹn àwa máa ń lo ti nǹkan ìbílẹ̀. Ẹ má gbàgbé pé òyìnbó tó ṣe kómà tó mọ̀ wípé lágbájá yóò tí ì kú. Lágbájá yóò tí ì sọdá. Ọ̀nà ẹni yóò tí ì jìn. Do you understand me? Ọ̀nà ẹni yóò tí ì jìn. Okay o. Ó dàbí pé tẹ́ ẹ bá gbé ènìyàn dé hospital tí wọ́n rush ènìyàn dé hospital gbùgbùgbùgbùgbù tí wọ́n gbé délé ìwòsàn gbàràgbàràgbàràgbàrà. Ẹ máa gbọ́ nǹkan tí àwọn dókítà máa sọ fún yín. Wọ́n á ló wà ní kómà. Abẹ́ ti rí ẹ ti gbọ́ nǹkan tí mo wí. Báwo ni òyìnbó ṣe mọ̀ pé èèyàn wà ní kómà? Ẹni tó ti kú. Ó ti kú o. Ṣùgbọ́n òyìnbó dictate pé ọ̀nà rẹ̀ ò tí ì jìn. Ọ̀nà ẹni yóò tí ì jìn. Òyìnbó mọ̀ pé ọ̀nà rẹ̀ ò tí ì jìn. Wọ́n wá sọ fún yín pé àwọn máa fún ní gbogbo nǹkan. Wọ́n wá fa gbá sí lára. Wọ́n á fi àwo sí lára. Wọ́n á fa kòkò bàbà àsàsùn sí lára. Wọ́n á fa gbogbo nǹkan sí ní ara. Ṣé ń gẹ́ẹ̀tì mi ẹ̀yin èèyàn mi? Wọ́n máa fa many things sí ní gbogbo ara. Tán bá ti wá fà sí lára, ibẹ̀ yẹn ni wọ́n ti wá sọ fún yín pé kò tí ì kú tán. Ọmọ àǹtí mi, wọ́n wá sọ fún yín pé kò yè tí ì sọdá. Ó sì lè jí padà. Báwo náà ṣe mọ̀ pé ó lè jí padà? Bọ̀tẹ́ yìí ò béèrè lọ́wọ́ ẹni yẹn o. Bọ̀tẹ́ ẹ béèrè lọ́wọ́ òyìnbó yẹn o. Ẹ béèrè lọ́wọ́ òyìnbó tó sọ fún yín wípé ó sì lè jí padà o. Òyìnbó tó sọ fún yín pé ẹ jẹ́ ká fi gbogbo ẹ́ńjìnì sí nínú ara. Oxygen and many more. Ẹ jẹ́ ká fi sí nínú gbogbo ara. Ó á jí padà. Ó níye wákàtí àti ọjọ́ tí ó lò nínú ojú ọ̀run. Ṣùgbọ́n kò tí ì sọdá. Bó bá sọdá tán sọ̀hún, wọ́n á sọ fún yín. Ń la wá ìbílẹ̀ ń lò. Ń làwọn oníṣẹ̀ṣe oníṣẹ̀ǹbáyé ń lò. Ń làwọn bàbá wa ń lò gbà yẹn. Ń làwọn bàbá wa ń lò nígbà ni. Táwọn bàbá wa fi mọ̀ wípé ẹni yóò tí ì kú. Ẹni yóò tí ì sọdá. Ṣùgbọ́n àwọn bàbá wa wà á lo. Àwọn bàbá wa wà á
conclusion of election, from printing of ballot papers, falsification of election results, widespread disruption, irregularities and malpractices, without providing particulars of the polling units where the alleged malpractices took place. Are too generic, vague, lacking in any particulars, and they are not tied specifically to any particular polling unit or any particular number of people who are alleged to be disenfranchised.
Tábà tí wá jí ẹni yẹn padà wá sílé ayé tán, tí wọ́n dá padà wá sílé ayé, ẹ̀yẹn wá máa kí ẹni pé ó jí dìde, iṣẹ́ ń lẹ́yìn ṣe tẹ́yìn ò lè ṣe ń làwọn ṣe. Ẹ sì tún ń pè wọ́n lóní nǹkan, ẹ tún sọ pé kò sí sí Ọlọ́run nílẹ̀ Yorùbá. Àmọ̀dí Yorùbá tó mọ̀ láwọn bàbá wa ń gbà náà, gbogbo àwọn nǹkan yẹn dà, wọ́n dìtẹ́ẹ̀tì ni pé wọ́n ti kú. Ẹ jẹ́ ká wo kéèsì yìí tán.
To further particulars, the Apex Court held in PDP versus Tiny that, and I quote, an application for an order for further particulars is merely a shield in the hand of a party so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, and devoid of necessary particulars as the appellant's was in the instant case. Unquote. The sober consideration of the decisions of the Supreme Court in relation to the requirements of pleadings, paragraph 4, of T, the first schedule to the Electoral Act 2020. On the one hand, and the decisions of the Supreme Court on the provision of paragraph 17 of 1 of 2, the first schedule, the Electoral Act 2022 relating to further particulars on the other hand, shows that whilst in cases such as Abubakar versus Eraduam, Ombugadu versus Philip, the Supreme Court had held that a respondent who complains of vagueness of arguments in an election petition should avail himself of the provision of paragraph 17 sub 1, first schedule to the Electoral Act, seek for further particulars or the direction of the tribunal or court. The decisions of the Apex Court, especially in PDP, INEC, Belgore and Ahmed, have specifically held that where arguments in the petition are grossly imprecise, generic, such arguments will be incompetent, liable to be struck out. Also on this Ipiazu. It is therefore clear that the state of the law, as could be deduced from the various decisions of the Apex Court, is that the provision for further particulars, as stated in paragraph 17(1), first schedule to the Electoral Act 2022, will only come into play where the petition itself contains material or necessary particulars. In other words, paragraph 17 sub 1 of the first schedule to the Electoral Act 2022 does not bar a respondent from applying under paragraph 4 sub 7 of the first schedule to strike out arguments in a petition which are grossly inadequate, insufficient, devoid of material or necessary particulars. This is because operational words in paragraph 17 sub 1 is further particulars. This means there must be some material particulars already pleaded in the petition before further particulars can be sought by the respondent. As born from the Apex Court decision in Belgore Ahmed, PDP, INEC, and Ipiazu and Oti, the law is clearly settled that specifying the particulars of polling units or places where irregularities are alleged to have occurred are material particulars in an election petition. Arguments in an election petition which allege irregularities or malpractices but fail to specify the polling units or places where the irregularities or malpractices occurred are bereft of material particulars, and such arguments are incompetent and liable to be struck. As specifically stated in PDP and INEC, petitioner who has failed to state such material particulars cannot invoke the provision relating to further particulars as a sword against the respondent in order to cure the incompetence of such argument. With respect, it is a misconceived argument on the part of the senior counsel for the petitioners to state that the latter decision of the Apex Court in Ombugadu and Sule Supra, which relates to further particulars under paragraph 17(1) of the first schedule, has departed the specific decisions of the Apex Court in Belgore Ahmed, PDP, INEC, Ipiazu and Oti, and several others. The mandatory requirements for stating material facts as provided in paragraph 4(1), first schedule to the Electoral Act. Contrary to the contention of the petitioners, the decision of the Supreme Court in Ombugadu, Sule Supra, has merely reiterated the legal position relating to further particulars as provided in paragraph 17 sub 1, first schedule to the Electoral Act 20. It has not departed from the above specific decisions of the Apex Court on the materiality of specifying in an election petition polling units or places where irregularities and malpractices are alleged to have occurred. Now, a look at the arguments in the petitioner's petition shows that the petitioners have only alleged various irregularities and malpractices, but failed to specify the particular polling units or specific places where the alleged irregularities and malpractices have occurred. For instance, paragraph 9 of the petition, where the petitioners avert that, and I quote, in appropriate cases, these agents raise complaints about anomalies where they occurred and reported such complaints to designated officers of the second respondent and the first respondent, unquote. Petitioners fail to specify the anomalies, the places where the anomalies occurred, the agents who complained, and the designated officers of the second petitioner and the first respondent to whom the complaints were made. In paragraph 60 and 61 of the petition, where the petitioners allege that the first respondent, and I quote, suppressed the actual scores obtained by the petitioners by deliberately uploading blood from EC8As on the IRF in 18,088 polling units. Petitioners did not specify the polling units, but only stated that they will rely on spreadsheets containing the polling units codes and details of the 18,088 polling units, as well as the authentic results in the said polling units. Paragraph 66 and 67, where the petitioners allege that the first respondent embarked on, and I quote, massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, unquote. They did not specify the polling units where they allege there were no elections. Incorrect results that were uploaded and which are the correct results. Again, in paragraph 68 to 71, where the petitioners allege that the scores obtained by them were, and I quote, unlawfully reduced and added by the first respondent to the scores of the second respondent, unquote. They failed to state their scores that were reduced and added that was the second respondent by the first respondent, and the figures that shows that the first petitioners won the election. In paragraph 72, 73, 76 to 78, where the petitioners allege overvoting, they merely stated that they will, and I quote, rely on the forensic reports of the election materials showing that the votes cast in the polling units in Ekiti State, Oyo State, Ondo State, Taraba State, Osun State, Kano State, Yobe, and Niger States exceeded the number of votes accredited on the beavers in those states. Petitioners failed to specify the polling units in those states where the overvoting occurred, the number of votes affected, the margin of lead, which they claim that the voters who ought to legitimately vote in those polling units. In paragraph 73 of the petition, petitioners only stated that they will, and I quote, show that in the computation and declaration of the results of the election, based on uploaded the votes recorded for the second respondent did not comply with the legitimate process of computation of the result and disfavored the petitioners, unquote. In Rivers, Lagos, Taraba, Benue, Adamawa, Imo, Bauchi, Borno, Kaduna, and Plateau, and other states of the Federation, petitioners neither specified the uploaded results nor the votes illegally recorded by the second respondents and how they were disfavored. Paragraph 83 of the petition, where the petitioners claim that the first respondents scored the majority of lawful votes cast at the election, they did not state the majority of lawful votes they claim to have scored, especially as elections and the determination of who won is about figures. In paragraph 99 of the petition, where the petitioners say they will rely on Form EC8As to establish that substantial votes were unlawfully credited to the second respondent, they failed to state the figures of the unlawful votes credited to the second. In the petition, petitioners merely made generic allegations of various irregularities and malpractices against the respondents without specifying the polling units, collation centers, or specific places where the alleged irregularities and malpractices occurred. Rather, petitioners only stated that they will rely on spreadsheets, inspection reports, and forensic expert analysis, which they say they have incorporated in the petition by reference. But none of the spreadsheets, inspection report, and forensic expert analysis was attached and served along with the petition on the respondent. Rather, they were only listed as items 35 and 36 in the list of documents to be relied upon by the petition. It is only in paragraph 62 and 64 of the petition why the petitioners allege that the first respondents suppressed the lawful votes of the petitioners and inflated the votes of the second and fourth respondents in Rivers and Benue states. That the petitioners gave figures of the votes, where the petitioners gave figures of the votes suppressed for the petitioners and those inflated for the second and fourth respondent, and also stated that they claim to be the actual figures scored, what they claim to be the actual figures scored by them and by the second and fourth respondent. But all other paragraphs of the petition where irregularities and malpractices were alleged are bereft of any material details, polling units or places where they were alleged to have taken place, or the figures of votes alleged to have been suppressed, inflated, or inflated. It is also pertinent to observe that in paragraph 79 of the petition, where the petitioners alleged corrupt practices, they merely stated that they are repeating their pleadings in support of the grounds of non-compliance, to be in support of their allegation of corrupt practices. It should be noted, however, that not every ground of non-compliance will amount to corrupt practice. In fact, the standard of proof of non-compliance differs from that of corrupt practice, while standard of proof of non-compliance is on the balance of probabilities, that of corrupt practices is beyond reasonable doubt. The PDP, INEC, Mohamed Wamako, Board of Customs and Excise versus Alaji Ibrahim Barrow, citations on the record. It is instructive that in paragraphs 3.2, 3.21 of their submission, in opposition to the first respondent's objection, petitioners appear to have conceded that in the arguments of the petition, they have not specified the particular polling units where the alleged irregularities and malpractices occurred, or specified the figures of the votes or scores which they are alleged to have been suppressed, inflated, or inflated. Rather, they stated that the details of the polling units are contained in the spreadsheets and forensic analysis reports which they have incorporated and made part of the pleadings by reference. Particularly on this paragraph 67 of the petitioners further argued that since the respondents have failed to apply for further particulars under paragraph 17.1 and 2 of the first schedule to the Electoral Act, they are deemed to have understood those arguments. However, by paragraph 15 of the first schedule to the Electoral Act 2022, when the petitioner claims, and I quote, that he had the highest number of valid votes cast at the election, the party defending the election or the return at the election shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove the hearing that the petitioner is not entitled to succeed, unquote. This provision presupposes that the petitioner has a first duty to state clearly in his petition the particulars of such votes, in respect of which he claims to have scored the highest number of valid votes, and thus entitled to be returned as the winner. This also presupposes that it is only after the petitioner has supplied the particulars of the votes in support of his claim that he scored the highest number of valid votes that a respondent will then have a duty to object to any part of the particulars of such votes supplied by the petitioner in order to show that the petitioner is not entitled to succeed. With regard to the petitioner's contention that they have incorporated into the petition by reference the spreadsheets and forensic analysis report containing details of the polling units where they allege that the irregularities and malpractices occurred, it is right that for a document to be properly incorporated as part of pleadings by reference, the document must not only be referred to in the pleadings, but it must also be included as part of the pleadings to be served on the adverse party, so as to enable the adverse party to properly respond to same in its defense. Indeed, in all the cases of EFCC reign, Ekomu Polo versus Edere Moda, Marine Management Associates Incorporated versus NMA, and Jinjadi and Omako Supra, which were relied upon by the petitioners. The documents which were incorporated as part of the pleadings by reference were served along with the pleadings on the adverse party. Considering a similar scenario, this court by Ayola, SCA, as Idemos, held in Nigeria Merchant Bank PLC vs. Ayedun Investment Limited as follows, and I quote, "Before I part with this appeal, it is pertinent to advert one pleading question raised in this pleading in regard to the consequence of a party pleading that he will rely on certain unspecified documents at the trial. The plaintiff contended that such arguments made the contents of such document part of the pleading. In this case, the plaintiff in paragraph 30 of the statement of claim pleaded thus: the plaintiff at the trial will rely on all letters and documents between the parties pertaining to this. Although the principle is established that if an agreement, the writing referred to in a pleading, becomes part of the pleading, and it is open to the court to give the agreement its full legal effect, irrespective of the term used in the pleading, indicate such effect, that proposition of law should not be used to cover such armament as shown above, which lacks specificity. Besides, a report such as Exhibit P22 in this case, prepared by a witness for the plaintiff and tendered the trial by the witness, cannot be described as documents between the parties pertaining to the suit. At the appropriate time, when the occasion arises, the true ambit of the proposition of law in such case, such as Bank Genesis versus Petai Limited, ought to be defined, unquote. In the instant case, the spreadsheet and forensic report, which were documents prepared by the petitioner's witnesses, were not served along with the petition on the respondent, but were only listed as documents to be relied upon at trial. I'm not oblivious of the petitioner's argument in relation to paragraph 4, sub 5, sub C of the first schedule to the Electoral Act 2022, which provides that the election petition shall be accompanied by, quote, copies or list of every document to be relied on at the hearing of the petition, quote. This provision undoubtedly only relates to front-loading of documents to be relied upon by the petitioner as his evidence during trial. Contrary to the petition, it is also noteworthy that the spreadsheets and forensic reports which the petitioners claim to be incorporating into the petition by reference are actually documents prepared by the petitioner's witnesses. In other words, spreadsheets and forensic reports are not documents which are outside the control of the petitioners and which they have obtained by subpoena. Being the petitioner's own documents, they ought to have served those documents along with petition on the respondent, so as to enable the respondent to counter same by engaging their own experts, appropriately respond to same if they so desire. That indeed is the essence of pleadings, so as to avoid taking the other party by surprise. Petitioners have also tried to argue that the respondents, having joined issues on the general allegations contained in the petition, they are deemed to have understood same. With respect, this is also not a tenable argument in view of the grossly generic allegations made in the petition. Faced with a similar scenario, this court, Ogungwimiju JCA, as he then was, RJC, held in Udiaga and another was Omegara, as follows, and I quote, the argument of appellant's counsel that the respondents did not adequately traverse the petition is unfounded. The petition itself contained general complaints. There was no effort in point in the pleadings, the various places where corrupt practices, non-voting, use of violence, forgery, rigging in polling units, massive thumbprint of ballot papers, fictitious entry of election results took place. Therefore, there was a general corresponding reply denying the allegations in general terms from the respondents. If the petitioners did not plead particulars, how could the respondents traverse non-existent particulars? Arguments in the appellant's pleadings should have contained details of the allegations and complaints which the respondents could reply in detail in their own pleadings. Appellants expected the respondents to reply to the various specific allegations contained in the witness statement, filed along with the petition. That is not the correct procedure. Those specific allegations should have been in the pleadings. Pleadings must show the facts disputed, while the witnesses would give evidence of these facts. In election petitions, it has been held that there is the need for particulars where required in order to prevent taking adverse party by surprise. It is not the function of particulars to take the place of necessary arguments in pleading, unquote. Indeed, in a presidential election like the one being challenged in this petition, where it was held in 176,846 polling units, 8,809 wards, 774 local government areas, 36 states, and the Federal Capital Territory, it is unimaginable that governments in the petition which merely allege irregularities and or malpractice without specifying the particular polling units or particular collation centers where the irregularities or malpractices have taken place will be regarded as proper, merely because the respondent has not requested for furth particulars. Belgore Ahmed and PDP INEC. Also, when an election petition is by nature a declaratory action, in which the petitioner succeeds only on the strength of his own case and not on the weakness of that of the respondent. Busari versus Adepoju, Oyetola versus Adeleke, and Anazong versus Onubogu, citations on them. It is in this respect that the petitioner has an obligation to set up a clear, unambiguous, precise, and positive case in his pleadings, since pleadings is the foundation of a party's case, and it is to the pleadings that the parties to litigation, as well as the court, are all bound. See Enang and others. It is in the light of all the foregoing that I find and hold that the motions of the respondents listed above succeed. In consequence, paragraphs 9, 60, 61, 66, 67, 68, 69, 70, 71, 72, 73, 76, 77, 78, 83, and 99 of the petition, which have failed to state the specific polling units, operation centers, or the specific places where the irregularities and malpractices are alleged to have occurred, or the figures of votes which are being claimed are grossly vague, imprecise, nebulous, and bereft of material particulars, and have thus failed to meet the requirements of paragraph 4, sub 1, sub D of the Electoral Act 2020. According to paragraph 4, sub 7 of the said schedule, said paragraphs are consequently hereby struck. On the first respondent's prayer to strike out paragraphs 57 and 58 of the petition for being inconsistent with paragraphs 65, 67, 70, and 71 of the petition, the essential contention of the first respondent is that while paragraph 57 and 58, whilst in paragraph 57 and 58 of the petitioners have alleged that the first respondent failed to comply with the order of inspection granted by the court, petitioners have in paragraph 65, 67, 70, and 71 stated that they will rely on the report of the inspector. Additionally, first respondent also argued that the first petitioners have alleged that the election was marred by corrupt practices and was not conducted in substantial compliance with the Electoral Act 2022. They have also alleged that they have scored majority of lawful votes cast and should be declared the winner. Relying on some cases which are produced here, first respondent urged the court to strike out the paragraphs as well as prayers 1 to 4 on the one hand, and prayers 5 sub 1 and sub 2 on the other hand for being inconsistent. Conversely, the petitioner contend that the law allows them to plead conflicting facts insofar as they have claimed alternative reliefs. They referred to the alternative reliefs at pages 35 to 37 of the petition, relied on some cases which are reproduced here, as well as the ruling on similar objection by the 2019 Presidential Election Court in the previous case. As rightly submitted by the petitioners, the reliefs in this petition, which I have reproduced at the beginning of this ruling, are undoubtedly sought in the alternative. The settled law is that reliefs can be sought in the alternative, and where so sought by a party is at liberty to plead conflicting facts in line with the alternative reliefs he has sought. In Adilije versus Umaogu and others, this court, Ogunwumiju Jesse, as he then was, held that, and I quote, in civil litigation and indeed in election matters, the party can make two seemingly contradictory pleadings, leading to two different heads of claim. That is why a petitioner can claim that the election be annulled for reason of substantial non-compliance, and in the same breath claim that he won the election by a majority of votes. Petitioner may plead the same set of facts around alternative relief. Those pleadings are not ipso facto held to be self-contradictory. The court can only grant one relief, as the party must decide which relief is best supported evidence on record. Unquote. Also on this metal construction West Africa Limited was a body citation given. In any case, first respondent, which is the body that conducted the election and to whom the first petitioner's nomination documents were submitted by the second petitioner, admitted in paragraph 4 of the petition, wherein petitioners averred that the first petitioner was duly sponsored by the second petitioner, whose platform the first petitioner contested. Therefore, I have no hesitation in discountenancing this ground of. Now, second category of objections or applications. These are the categories that challenge the competence of the petition on some of its grounds. Second category of the respondents' applications that challenge some of the grounds of the petition and all the competence of the petitioner are as follows. First, respondents' motion filed on the 19th of April 2023, seeking 1. Order striking out ground 2, paragraphs 333 to 79 are released 5, 1 and 2 of the petition on transmission of election results for being cut off by issue stuff. 2. Order striking out paragraphs 20, 1, 21, 23, 24, 25, 26, and 27 on nomination of the second and third respondents for lack of jurisdiction. Second and third respondents' motion filed on the 12th of May 2023 seeking for the following. 1. Order striking out or dismissing the petition for being incompetent and defective. 2. Order striking out grounds 1, 2, and 3 of the petition. 3. Order striking out reliefs 1, Roman 1 to 3, 2, 3, 4, Roman 1 to 4, 5, Roman 1 and 2 of the petition. The above two motions are predicated on several grounds, which are reproduced here. It is the view of this court that the issue relating to ground 1, challenging the qualification of the second respondent to contest the election, the issue relating to the competence of ground 2, relating to the allegations of corrupt practices and non-compliance of the Electoral Act 2022, and the plea of estoppel in relation thereto, as well as the issue relating to competence of the reliefs brought in this petition, are matters on which the parties have joined issues in the main petition, the merits of which will be decided after considering the pleadings and evidence laid in the petition. It is the settled position of law that a court should not comment on or decide at preliminary stage matters or issues which are supposed to be decided in substantive case. Wanko and others versus Eradua. Ocholi on Onojo James SAN versus INEC, citations on the record. Hence, while leaving those issues to be dealt with on the merits of the petition, we shall determine at this stage the objections relating to the petitioner's locus standi, non-joinder of necessary parts or some paragraphs of the petitioner's lack of locus standi of the first petitioner. Second and third respondents and the fourth respondents in this motion filed, their motion filed on the 8th of May 2023, also objected to the first petitioner's locus standi to bring this petition. Principal contention is that the first petitioner was in contravention of Section 77 sub 3, the Electoral Act 2020. They argue that the first petitioner, who was a member of the People's Democratic Party and who was screened as one of its aspirants for the presidential election, only resigned his membership of that party on the 24th of May 2022, joined the second petitioner on the 27th of May 2022. They contended that as at 30th of April 2022, first petitioner could not have been in the register of members, second petitioner, which it submitted the first respondent 30 days before the presidential primary election, as mandated by Section 77 sub 3 of the Electoral Act 2020. Since the first petitioner is not in the membership register submitted by the first respondent by the second petitioner, first petitioner lacks the locus standi to challenge the outcome of the election. By contrast, the petitioners submitted that the issue of membership of a political party is a domestic affair of the political party concerned. The court lacks the jurisdiction to intervene, relied on the cases that are reproduced here. The courts have consistently held in a plethora of cases that the issue of membership of a political party is an internal affair of it is not a justiciable issue, and courts have no jurisdiction to intervene. Anang versus Asukwo, others, Tani and Galadima, and Tumbido versus INEC, citations on the record, as well as all the cases cited above by the petitioner. The provision of Section 77 sub 3 of the Electoral Act 2022, which only mandates every political party to submit the register of its members 30 days before its primaries, cannot be invoked by the respondent for the purpose of challenging the first petitioner's membership. The second petitioner. It is only the second petitioner that has the sole prerogative of determining who are its members. And having sponsored the first petitioner as its candidate for the presidential election, first petitioner has satisfied the requirement of being a member. Second petitioner as provided for in Section 131 sub C, the 1999 Constitution. It is not within the rights of the second and third respondents and the fourth respondent question the first petitioner's membership, second petitioner. This ground of objection is hereby overruled. No enjoinder of necessary parties. First respondent in his motion of 19th of April 2023, and the second and third respondents, as well as the fourth respondent, raised the issue of non-joinder of Abubakar Atiku or the People's Democratic Party, who came second in the presidential election as respondents to the petition. The contention of the respondent then is that since by relief 1 Roman 3, 4 Roman 4 of the petition, petitioners who came third the presidential election are seeking to be declared the winners of the election. Petition cannot be effectually and completely determined without the joinder of Abubakar Atiku or the People's Democratic Party, who came second in the election. as respondents to the petition. For that reason, the respondents have contended that this court lacks the jurisdiction to entertain the petition as constituted. Place reliance on JGD and INEC. Buhari and Obasanjo citations on the record. No position, however, petitioners relied and contended that only statutory respondents provided in Section 133 of the Electoral Act 2022 are necessary parties to the petition. Petitioners are not under any obligation to join Abubakar Atiku and the People's Democratic. By Section 133 of the Electoral Act 2022, the statutory respondents and election petition are 1. The person whose election is being complained of, and 2. The Independent National Electoral Commission, which will also be deemed to be defending the petition on behalf of its officers whose conduct complained of. In the cases of Obasanjo and Yar'Adua and Buhari and Yusuf Supra, cited by the petitioners, the Supreme Court categorically held that only the statutory respondents stated in Section 133 of the Electoral Act are necessary parties, and that losers at an election who are not statutory respondents are not necessary parties in an election. By the import of Section 133 of the Electoral Act 2022, the contest in an election petition is strictly between the petitioner who challenges the outcome of the election, the person who was declared the winner of the election, and the commission that conducted and declared the outcome of the election. This means that every candidate who lost the election and who is desirous of challenging the outcome of the election is expected to file his own petition against the winner of the election, and in so doing is not required to join any other candidate who lost the election like himself. It is in furtherance of this that paragraph 50 of the first schedule to the Electoral Act 2022 requires an election tribunal or court to consolidate 2 or more petitions which are presented in relation to the same election or return. As rightly submitted by the petitioners, the case of JGD and INEC cited by the first respondent is clearly not applicable to this case. Since the decision in that case is that Maimala Buni was a necessary party because by the provisions of Section 183 of the 1999 Constitution would have ceased being a governor of Yobe State if the case made out in the petition that you could not combine the offices of governor of Yobe State, acting chairman of the All Progressive Congress is sustained. This case, Abubakar Atiku, People's Democratic Party, who were only runners-up in the presidential elections, are not necessary parties as they are not statutory respondents to this petition. The petitioners hearing have no obligation to join them in this. Again, in Buhari and Obasanjo Supra, relied upon by the respondents, the Supreme Court reconfirmed its decision in Buhari and Yusuf Supra that there is no obligation on the petitioner to make a candidate who lost an election like himself. Also, as in this case, Abubakar Atiku and the People's Democratic Party have filed a separate petition number CAPEPC 0523, which, as mentioned in the earlier part of this court, has consolidated with the petition signed paragraph 50, the first schedule to the Electoral Act 2020. This ground of objection to the competence of the petition is meritorious. On the evidence over the competence petition, view that the list which the court can grant an election petition as statutory, as provided in Section 136 sub 1, sub 2, sub 3 of the Electoral Act 2020. Therefore, the determination of whether the relief sought by a petitioner are grantable can only be made after trial. Challenge to competence of the petitioner's replies. The third category of the applications of the respondents seek to strike out the petitioner's replies or some paragraphs of the replies. These are first respondent's motion filed on the 9th of May 2023 seeking 1. Order striking out the petitioner's reply, the first respondent's reply for being incompetent. 2. In the alternative, order striking out paragraph 15, 16 Roman 1 to 7, 17 to 20, 22, 24, 25, 27 to 32, 34, 36, 37, 38, 40, and 41, petitioner's reply, offending the provisions of the first schedule to the Electoral Act 20. Second and third respondents' motion filed on the 13th of May 2023, seeking for order striking out petitioner's reply of 21st April 2023 for being incompetent. 2. In the alternative, order striking out paragraphs 8 to 17, 19 to 32, 34 to 42 of the petitioner's reply for introducing new facts. fourth respondent's motion filed on the 8th of May 2023 prays for 1. Order striking out paragraphs 15 to 32 of the petitioner's reply, the fourth respondent's reply, as well as the witness statement on oath with failure to deny the fourth respondent's allegation. 2. Order striking out paragraphs 5 Roman 1 to 9, 15 Roman 1 to 7, 16 Roman 1 to 7, 17 Roman 1 to 7, 18 Roman 1 A to H, 18 Roman 2 A to E, 18 Roman 3, 5 and 7, A to B, A and B, Roman 8 A and B, Roman 9, Roman 11, 20 to 25, A to D, 26 Roman 1 and 2, 27 to 31 of the petitioner's reply, the fourth respondent's reply for raising new issues. All the respondents challenge the competence of the petitioner's reply, their respective replies, or in the alternative the paragraphs thereof, which they have variously listed above. Their essential contention is that the replies, or in the alternative the paragraphs thereof, have either raised or introduced new facts aimed at substantially altering the grounds and reliefs in the petition, or are mere repetition or a hash of the facts contained in the petition, contrary to the provisions of section 16, paragraph 16, sub 1A and B of the Electoral Act. Respondents replied on several shell authorities which are reproduced. In response, the petitioners have argued that they have merely reacted to the fresh/new issues raised in the replies of the respondents, which attempted to justify the grounds of non-qualification. The second and third respondents, as well as the non-compliance by the first rely on Silva and INEC, PDP versus Ezo Onwuka, petitions on the record, and urge the court to discountenance the objections of the respondents of all the petitioners. Now, paragraph 16, sub 1A of the first schedule to the Electoral Act 2022 provides as follows, and I quote: if a person in his reply to the election petition raises new issues or facts in defense of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, petitioner's reply, and answer the new issues of fact. So, however, that A, petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him. Quote: by the import of paragraph 16 sub 1A of the first schedule, petitioner may, in filing a reply, respond to allegations of new facts raised in a respondent's reply to the petition, provided he does not in so doing amend or add to the petition. It is instructive to observe that the words used in paragraph 16(1)(a) are, quote, new facts, grounds, or prayers tending to amend or add to the contents of the petition, unquote. The word new suggests something which is not there, while the word amend signifies modification. Add, on the other hand, means to increase. What the provision envisages, therefore, is that the reply of a petitioner must strictly be confined to the new facts raised in the respondent's reply and must not go over that to attempt, amend, or add to the petition. See All Progressive Congress versus People's Democratic Party, Njadi and Wamako, Adepoju versus Awoduyi Lemi, Ikoro versus Izunaso, citations on the record. Indeed, in succinctly explaining the new issue which should attract the reply, the Supreme Court had held in Ejesimba versus Onuzuriki as follows, and I quote: a new issue to attract a reply must in law be really new in the sense of being brand and fresh. The issue must be really new, the statement of claim, in that it was not existing therein and was therefore brought into existence or introduced for the first time the statement of defense by the defense. The new issue, or both its contents and materiality, must be further and additional to the statement of claim. Thus, the mere fact that a defendant states his own side of the case does not necessarily make it new, particularly when the plaintiff has told a contrary story in the statement of claim. In such a situation, the case stated by the defendant amounts to joining issues with the plaintiff. That does not bear the name of a new issue in law. The new issue arises where the plaintiff did not avert to or touch the contents of the defendant's arguments in anticipation. The defense argument was introduced pleadings for the first time and therefore unique and novel discipline. Unquote. A careful examination of the petitioner's petition, the first, second, and third, and the fourth respondents' respective replies, and the replies which the petitioners filed in response thereof, reveals that apart from rehashing what they have already averred in their petition and denying what the respondents have stated in their respective replies, petitioners also introduced new facts in their replies, the respondents' replies, which were not contained in their petition. This is in clear contravention of paragraph 16 sub 1A, first schedule to the electoral act. Paragraph 16, 1 to the law as encapsulated in paragraph 16(1)(a) of the first schedule to the Electoral Act quoted above forbids new additions or amendments by a petitioner which are not contained in the petition, because such new additions or amendments will prejudice the respondents and breach the respondents' fundamental right to fair hearing, guaranteed by Section 36(5) of the Constitution of the Federal Republic of Nigeria, 1990. Since the respondents will have no opportunity to respond to those new issues, additions, or amendments. See PDP and another versus INEC, others. Maku and another versus Alma Makura and others suggested. An examination of the paragraph 4, Roman 3, Roman 4, and Roman 5 of the first respondent's reply shows that the paragraphs does not raise any new issue, contrary to the assertion of the petitioners. In paragraph 15 of their reply, the first respondent's reply to the petition, it's only a response to paragraph 7 and 8 of the petition. But the petitioner's argument in the same paragraph 15 that the first respondents officials at the polling units failed to give clear copies of the results of the election from ECHA to the petitioner's agents, as the pink copies given by the petitioner's agents were very faint and unreliable, a new fact which tends to amend the petition. Paragraph 16, Roman 1, 7, 17, second part of 18, 22, 24 of the first respondent's reply are traverse of paragraphs 21, 27 of the petition. Hence, paragraph 16 of the petitioner's reply, which purports to respond to new issues in paragraph 17, 18, 19, 20, 21, 22, and 24 of the first respondent's reply, actually contain new facts, which will amount to amendment. Also, paragraph 17, 18, 19, 24, 25, 27, 28, 29, 30, 31, 32, 34, 35, 36, and 37 of the petitioner's reply, the first respondent's reply are either a rehash of the facts already averred in the petition or contain new facts which will amount to amendment of the petition. With respect of the petitioner's reply to the second and third respondent's reply, the petition latter are seeking for an order striking out paragraphs 8 to 42 of the petitioner's reply. However, a careful examination of those paragraphs shows that only paragraph 21 of that reply has raised a new allegation against the first respondent of attempts to manipulate the data uploaded on the back-end server of the AWS. The said paragraph 21 of the petitioner's reply to the second and third respondent's reply is hereby true. Similarly, petitioners have introduced new facts in paragraphs 16, 17, 18, 20, 22, 23, 24, 25, and 27 of their reply, some of which contain serious allegations of false respondents, which the false respondents has no opportunity. In contravention of paragraph 16 sub 1 of the first schedule to the Electoral Act, those paragraphs are also hereby true. That indeed is the rulings on the respondents' objections, various objections.
Well, as I was trying to explain earlier before we went for the break, we took all the judgments. After that, my learned brothers will now their own order to save time. Because the petitions are consolidated. So now we will go to the main petition number 3. In bringing this petition, the petitioners who were contestants in the presidential elections held on 26 February 2023 have challenged the declaration return of second respondent as the winner of the election and sought for the declaration and consequential reliefs, which I have reproduced in the beginning of this judgment. The petitioners have predicated their petition on the 3 statutory grounds earlier stated. Although in the ruling of this court on the objections of the respondents. Some paragraphs of petition replies have been struck out for state reasons. This court will take into consideration the entire affirmance in the petition, determine the merit otherwise of the petition in the interest of justice. At trial, the petitioners opened their case, tendering from the bar several certified true copies of electoral and other documents which were objected to by all the respondents, who reserved the reasons for their objections in the state of final address. Said objections were therefore admitted, the said documents were therefore admitted and marked as exhibits without prejudice to the objections of the respondents. The court ordered the respondents file separate addresses on their objections along with their final addresses. Proof of their petition: the petitioners called 13 witnesses who gave evidence as PW1 to PW13. Of those witnesses, only 3 had their witness statements on oath filed along with the petition, while the other 10 were subpoenaed witnesses whose statements were filed separately after hearing in the petition had commenced. The respondents objected to the competence of the subpoenaed witnesses, give evidence and adopt their witness statements on oath, and reserve the rulings for their objection to the state of final address. That prejudice to the objection, that witnesses adopted their respective witnesses' statement on oath, after which they were duly cross-examined by all the senior counsel for the respondents. Upon closure of the petitioner's case, the first respondent as well as the second and third respondents called one witness each in their defense. Both respondents did not call any witness, but opted to rely on the evidence already adduced by the other respondents, and that is state and cross-examination on behalf of the fourth respondent. At the close of evidence, parties filed and extend their respective final addresses, including separate addresses, support of their various objections which they raised in trial. So we shall now consider the respondents' objections to the competence of some of the petitioner witnesses and to the documents tendered by them during trial. To save time, skip the addresses of counsel, go to the resolutions of those issues. So, the resolution of the respondent's objection to witnesses and documents contained in page 84 of the judgment. On the first segment of the respondent's objection, all the respondents challenged the competence of PW3, PW4, PW5, PW6, 7, 8, 9, 10, 11, and 13. And the respondent's essential contention is that the witness statements on oath, both witnesses, on oath of those witnesses, of the petitioners were not lodged along with the petition, but were only filed during trial, contrary to paragraph 4 of 5B of the Electoral Act 2020. Section 285 of the 1999 Constitution as amended, which limits the time for presidential election petition, provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the election. In the same vein, Section 137 of the Electoral Act 2020 provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the election. Paragraph 4 of the first schedule to the Electoral Act 2022 stipulates the content of an election petition which shall be filed. In particular, paragraph 4.5 of the state schedule is as follows. The election petition shall be accompanied by A list of the witnesses that the petitioner intends to call in proof of petition, B, statements on oath of the witnesses. C. Copies or list of every document to be relied on at the hearing of the petition. Paragraph 6 of that paragraph. If the petition fails to comply with the above requirements, it will not be accepted for filing at the Secretary. Paragraph 14 sub 2 of the same schedule, the Electoral Act, then provides as follows. After the expiration of the time limited by A, Section 132 sub 7 of this Act for presentation of the election petition, no amendment shall be made. 1. Introducing any of the requirements of paragraph 41 contained in the final election petition file, or 2. Effecting substantial alteration of the ground for or the prayer in the election petition, or 3. Except anything which may be done under subparagraph 2A, Roman 2, affecting a substantial alteration of or addition to statements of facts relied on to support the ground or sustain the prayer election petition. And the sub D, paragraph 12, following the reply, no amendment shall be made. 1. Alleging that the claim of the seat or office by the petitioner is correct or false. 2. Except anything which will be done under the provisions of paragraph 2A, Roman 2, affecting any substantial alteration in or addition to the admissions or the denials contained in the original reply file or to the facts set out in the reply. The above quoted provisions of the Constitution, Electoral Act 2022, and the first schedule thereto have been thoroughly considered by the Supreme Court in several cases, including Okiam and other versus Mimiko and others, Gumbi JC, Oba and Vincent Rarume and others, Anik, Okuru, Ogi and others, PDP and Okuru and several others listed here. In Oke and Mimiko, the upper apex court by Ugumbi JC held as follows in the court. Paragraph 4, 1 and 5 of the first schedule to the Electoral Act, a composite analysis of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive, mandatory, conclusive. In other words, the provisions do not allow for additions, and hence, the procedure adopted by the appellants in seeking for an extension of time is nothing other than surreptitious attempt to amend it. This is obvious from the nature and substance of the application, especially where one of the grounds seeks to put in facts which are allegedly not available allegedly not available at the time of filing the petition, but only came into their possession after the statutory time limit allowed for the presentation of election petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, in paragraph 14.2 of the first schedule to the Electoral Act, the appellant by section 134 of 1 of the Electoral Act had been totally foreclosed in any amendment, which was in fact the hidden agenda promoting the application. The saying is true that even the devil does not know a man's intention. It can only be inferred from the act exhibiting that which is conceived in the heart, mind. Use of the word shall in paragraph 14 sub 2A of the first schedule to the Electoral Act mandatory and places a complete bar. Any form of amendment in file does not allow for an exercise of petition whatsoever. Further still, on a critical threshold of the application, relief 2 seeks to call additional witness to which with AEO. It is pertinent to state that at the close of pleading, parties have submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more but a clear confirmation seeking for an order of an amendment as rightly and ingeniously brought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provision section 285.5 of the Constitution, 134 of the Electoral Act, Laws of Court. In his concurring judgment in the same case, Nguta ASC specifically stated follows: the court, the additional or further witness positions ought to be allowed for a just and fair determination of the petition fresh facts as far as the tribunal, and which finding was endorsed by the lower court. This court will not interfere with the concurrent finding of fact of the two lower courts when the appellants have failed to show special circumstances for this court to do so. Different petitions are time bound, and the court will not allow the party to resort to any sort of subterfuge or frustrate the intention of the Electoral Act that petitions because of disbursement. The petitioners in this case have relied on the earlier decisions of this court in Omidiran versus Ete, Lasun versus Awoyemi, Supra, to argue that the 15 witnesses whose witness statements on oath were filed outside the time limited for the presentation of the petition are competent to testify because they are subpoena witnesses who do not work for the petitioner. However, it is important to observe that unlike in the present case, the subpoena issued at the instance of petitioner in the case of Omidiran and Ete and Lasun versus Awoyemi were decided under the Electoral Act of 2006, which did not have provisions similar to paragraph 4 sub 5, the first schedule to the External Electoral Act 2022. Secondly, the subpoenas in the above two cases were issued and served on adversaries, namely the resident electoral commissioners. Again, those two cases were decided before the introduction of Section 285, subsection 6 of the 19th Constitution of Federal Republic of Nigeria 1999, which mandates that an election petition shall be studied within 180 days from the filing petition. Thus, whilst this court in Omidiran and Ete and Lasun versus Awoyemi appeared to have adopted a flexible approach, the Apex Court had taken a strict approach in its latter decision for Oche and Mimiko. Indeed, in subsequent following the Apex Court's decision in Oche and Mimiko, this court, Ajim JCA, as he then was, now JC, highlighted this strict position of the law in Ogba versus Vincent at paragraph 46, 48, paragraph 8b, wherein he held as follows: I think that this court in Omidiran and Ete and the Supreme Court in Oche and Mimiko adopted different approaches in addressing the issue of whether the tribunal or court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election petition proceeding. Omidiran's case did not strictly enforce the time limits described in Section 141 of the Electoral Act 2006. The provision in the first schedule that in prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings in paragraph 1 sub 1 of the Election Tribunal and Court Practice Directions of 2006 on the content and form of the petition, held that the purpose of the first direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic application of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the Electoral Tribunal to court practice directions as overriding the rules of court election court cases. In Mimiko, the Supreme Court approached the issue in keeping with the current judicial end of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The Supreme Court has consistently, in a long line of cases, insisted on this strict and inelastic approach opposing electoral laws. The law has laid out estimate juries in Oche and Mimiko is that a witness position that is not filed along with the petition within the 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus: if there was an evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly for the tribunal
within the time limit specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition. Even if it had been withheld by any person, there are several ways to go about placing same before the tribunal. Evidence is very clear on this. Petitioners ought to have restored that figure, clause of court. The firm position of the Supreme Court, as stated in Okia Mimiko and followed by this court in Oba and Vincent Opera, is that by the combined provisions of Section 285 of the 1999 Constitution, Section 137, Subsection 7 of the Electoral Act 2022, and paragraph 4, 5, and 6 and 14.2 of the first schedule to the Act, every written statement of the witness which a party intends to call must be filed along with the petition within the time limited by Section 208.55 of the Constitution of Federal Republic of Nigeria as amended, and Section 132, Subsection 7 of the Electoral Act 2022. Once the time limited for filing of a petition has elapsed, the contents of the petition cannot be added to or amended in any manner or under any guise. Any written statement on oath of a witness filed outside that 21 days limitation will amount to a surreptitious amendment of the petition and a breach of paragraph 14 of the first schedule to the Electoral Act 2022. This is irrespective of whether the witnesses to be called are ordinary or expert witnesses and whether they are willing or in witnesses. Since then, this has been the consistent position, the law followed by this court. Indeed, in Okuru versus Obe, this court held this position by our learned brother Bolaji Yusuf, stated that court. From the records, PW3 and PW4 was summoned by subpoena issued by the tribunal and presented as expert witnesses. The question is whether this without more entitled the appellant to file their statements on oath outside the time set for filing the petition. Or the reply to the respondent's reply in answer to the petition. Of the humble view that whether an expert witness or not, the witness remains a witness. So the proviso to Order 3, Rule 3, Sub 1 of the Federal High Court, Civil Procedure Rules 2009, made applicable to an electoral election petition by paragraph 54 of the first schedule to the Electoral Act provides that the statements on oath of witnesses requiring subpoena from the court need not be filed at the commencement of the suit. The witnesses who require subpoena or summons shall, at the instance of the party calling them, be served with civil form 1A before the filing of the statements by witness. The application of that rule is with regard to and or subject to the provisions of the Electoral Act, not independent of the Act. Paragraph 54 reads, subject to the express provisions of this Act, the practice and procedure of the tribunal or the court in relation to an election petition shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction. The civil procedure rules shall apply with such modifications as may be necessary to render them applicable having regard to the provisions of this Act, as if the petitioner and the respondent were respectively the plaintiff and the defendant in an ordinary civil action. The provisions of the Electoral Act being substantive law shall override any rule of court which is contrary to provision. The subsidiary legislation must conform with the principal law, PNNPC and Afamfa Oil Limited. The proviso to Order 3, Rule 3.1 of the Federal High Court Rules 2009 cannot override or affect or whittle down the absolute and mandated provisions of Section 285 of the Constitution of the Federal Republic of Nigeria as 1999 as amending that an election petition shall be filed within 21 days after the date of the declaration of the result of the elections, and paragraphs 4, sub 1, 5, and 14.1 and 2, the first schedule to the Electoral Act, which stipulate the content of a petition. It is therefore clear that in law, the provisions of Order 3, Rule 3.1 of the Federal High Court Civil Procedure Rule 2009 cannot provide a platform for filing and using witness statements on oath not filed within the time limit set for presentation of petition, and which time cannot be extended for any reason under any guise. The focus of our decision in Ogba and Vincent Supra was the injustice in allowing a piece of evidence not covered by the pleadings were presented to the court when the opposing party would have no opportunity to react to it. It is my humble view that the position of the law, as can be gleaned from the section 2855 of the Constitution, paragraph 4, 14.2 and 16.1 of the First Schedule to the Electoral Act, is that a petitioner cannot be allowed to file and use documents or witness statements on oath filed outside the time set for filing petition, and to which the respondents would have no opportunity to react. Doing so will amount to creating an avenue which a petitioner can use to exploit to overreach the respondents. That is the stand of the Supreme Court, which and Mimico, number 1 Supra, followed by this court, Oba and Vincent Supra, source of court. Again, in Ararumi and another, but Anik and others, in which I wrote the lead judgment, therein are stated as follows. The law, therefore, is that the deposition of a witness must accompany the petition at the time of filing the petition. In other words, the written statement on oath of an intended witness must be filed along with the petition. Thus, any written deposition of a witness not filed along with the petition will not be countenanced by the court or tribunal. Therefore, means that a written deposition filed by a witness not listed in the petition nor his deposition front-loaded cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. I think that is what the tribunal decided in this case, in line with the decision in Oba and Vincent. The combined effect of paragraph 4.5, Roman 1 and 2, 14.1 and 3 of the First Schedule to the Electoral Act is that no witness can testify in chief before a tribunal if he has not deposed a written statement on oath, which must necessarily have been filed along with the petition. Close of court. From the foregoing judicial decisions, it is clear that in election petition litigation, whether the witnesses which a party intends to call are ordinary or aspire witnesses, and whether they are willing or abstain witnesses, their witness deposition must be filed along with petition before such witnesses will be competent to testify before the tribunal or court. It is instructive to observe that one of the leading senior counsel for the petitioners in this petition, Dr. Onyechi Ipiagu, SAN, was the lead counsel to the second respondent in Ararune and another versus Anik and others, wherein he successfully challenged the competence of a subpoena witness, Ama Ibom Abu, PW2, on the same ground that the witness statement on oath of the said witness was filed on 8/7/2019, long after the time limited for the filing of petition. Therefore, the petitioners in this case were well aware of the settled legal position on subpoena witnesses in election petitions, favored by the Supreme Court and by this court. Yet they embarked on subpoenaing PW3, PW4, PW5, PW6, PW7, 8, 9, 10, 11, and 13. 10 out of their 13 witnesses, whose witness statements on oath were not front-loaded along with the petition. The petitioners have tried to argue that the said witnesses are witnesses of this court. With respect, this argument is misconceived because the subpoena in respect of those witnesses were issued upon the request of the petitioners. The applications for the issuance of the subpoenas were duly signed filed at the registry of this court by the petitioner counsel, and the requisite fees paid, including filing fees and service fees as assessed, were duly paid by them before this court approved and issued subpoenas. Therefore, those witnesses are the petitioner witnesses and not witnesses of this court. Indeed, the procedure for calling of witnesses by the court is by short summons as stipulated in paragraph 42 of one of the First Schedule to the Electoral Act 2022. By the provisions of that paragraph, the tribunal or court may summon a witness as a witness who appears to the tribunal or court to have been concerned in the election. Clear from the provisions of that paragraph that is a person summoned by the powers under paragraph person subpoenaed at the request of a party to the case. In the instant case, PW3, who was subpoenaed at the request of the petitioners, is a staff of Channels Television who tendered exhibits PBH3 and PBH4, two flash drives containing third annual consultative meeting with leaders of political parties held on 26 October 2022. An interview with Mr. Festus Okoye, National Annual Commissioner, held on 12 March 2023, respectively. PW4, a professor of mathematics, who was engaged before the election by the petitioners, and whom the petitioners presented as a supreme expert witness, stated under cross-examination by the first respondent that he concluded his report on the 19th of March 2023 before the petition was filed. PW5 is a staff of Arise Television, who also tendered exhibit PCG2, a flash drive showing the INEC chairman delivering an address at the Chatham House, London, UK, on the preparations for the 2023 elections in Nigeria. PW6 is a staff of African Independent Television, AIT, who tendered exhibit PCH1, a flash drive of the program Democracy Day, anchored on 22nd November 2022, wherein the INEC chairman was shown giving a brief on the preparations for the 2023 general election. PW7, who claimed to be a cloud engineer and architect, incorporated, tendered exhibits PCJ3AF, which has reports of Amazon Web Services AWS dashboard, which she said she downloaded from the Amazon website. Under cross-examination, however, she not only admitted that she is a member of the second petitioner. Please, let us be serious. This is a serious matter, it's not a last one. She not only admitted that she is a member of the second petitioner, the Labour Party, but she had contested elections as a candidate for the second petitioner for House of Representatives election, conducted along with the president election 25th February 2023. Who claimed to be a cybersecurity expert engaged by the Labour Party on 10th March 2023, stated that he produced his preliminary report on 17th or 18th March 2023 before the petition was filed. He tendered exhibit PCK1, the metadata. PW9 is staff of Women and Health Initiative, a non-governmental organization, claimed to be an observer in the 25th February 2023 election, but stated that the subpoena was addressed to him personally and served at his village address. PW10 claimed to be an annual ad hoc staff who acted as a supervisor. He stated under cross-examination that the subpoena was addressed to him personally and not through INEC. PW11, who is a staff in the Legal Staff Department of National Information Technology Department Agency, NIDA, stated that the subpoena was addressed to him personally instead of his organization. As for PW13, who claimed to have acted as a presiding officer in the 25th February 2023 elections, stated that he was on subpoena. The subpoena, which was admitted as exhibit PCR, was, however, addressed to him personally and not through INEC. The department observed that above 10 witnesses were all witnesses who were available to the petitioners at the time of filing the petition. They were neither subpoenaed as adversaries nor subpoenaed as official witnesses. It is therefore beyond controversy that the witness statements on oath of those witnesses filed after the time limited for presentation of the petition had lapsed are incompetent, and the same witnesses had no virus to file in this petition. Their testimonies are embodied in their respective witness statements on oath. Being incompetent are accordingly struck out. With regard to the respondents' objections to the admissibility of documents tendered by the petitioners, the first objection raised by the respondents is to exhibits tendered through PW4, as to exhibits tendered through PW4, 5, 6, 7, 8, and 8. These are exhibits PCD1, PCD2, PCD3, PCE1, PCE2, PCE3, PCE4, and PF, tendered through PW4. Exhibits PCG1 and PCG2 tendered through PW5. Exhibit PCH1 tendered through PW6. Exhibits PCJ1, PCJ2, PCJ3, APF, and PCJ4 tendered through PW7. And exhibits PCK1 and PCK2 tendered through PW8. The said exhibits are, I have estimated them in judgment. The respondent's essential argument is that still the subpoena witnesses and their witness statements on oath are incompetent. The documents tendered through those witnesses cannot be countenanced by the court. Paragraph 41.3 of the first schedule to the Electoral Act 2022, oral examination of witnesses is not allowed. Witnesses are only to adopt their respective written depositions and tender in evidence all disputed documents or other exhibits referred to in their deposition. Paragraph 4.5b of the schedule, such written depositions of the witnesses must be filed along with the petition. Since the above exhibits are documents, including expert reports, which were tendered through the subpoena witnesses, whom we have already declared incompetent, because their witness statements on oath were filed in violation of the mandatory provisions of paragraph 4.5b of the first schedule of the Electoral Act 2022, the documents admitted through them, which form part of their evidence, are inadmissible and liable to be expunged from the record. In the case of Buhari and INEC, the petitioners have also argued that since the parties have agreed during pre-hearing session that documents properly certified by INEC will not be objected to, and the said documents were tendered from pursuant to pre-hearing order of this court, 23rd May 2023. The parties are bound by the order of the court. The same has not been appealed against by the second and third respondents. However, this contention of the petitioners does not represent the position of the law. It is stated that a court is not permitted in any event to admit an act on late. It stated that a court permitted to act in any event to admit an act on legally inadmissible evidence, even if such evidence had been admitted by agreement of the parties or under order of court in the course of hearing. Once such evidence is legally inadmissible, the court must reject it when giving its final judgment, even if that will amount to overruling itself by so doing. Ishanu and AfriBank are OY for JSC. Indeed, even in the case of Sani and Akwe, relied upon by the petitioners, this court at paragraph 20, paragraph B2A, restated the position of the law that even when pieces of evidence had been improperly received evidence, trial court as well as appellate court have the power to expunge it from the record and decide the case only on legally admissible evidence. On the objection of the respondent to the admissibility of the documents tendered as expert reports by the petitioners, which were admitted as exhibits PCD1, PCD3, PCE1 to PCE4, PCJ2, PCJ3A to F, and PCK1, the respondent's contention is that they are caught up by the provisions of Section 83 of Section 3 of the Evidence Act 2011, having been contrived for the purpose of this petition. It is settled law It is settled law that as provided in Section 83, subsection 3 of the Evidence Act 2011, and pronounced upon in several decisions of the appellate court that a document which is made by a party interested in a pending or anticipated proceeding involving a dispute as to any fact which the document tends to establish is inadmissible in evidence. As in Latoja and Ajimobi, where the Supreme Court, Peter Odili, JSC held as follows: our court. In respect of what is referred to as the person interested, I shall refer to the cases of Nigeria Social Insurance Trust versus Cliffco, Nigeria Limited. As regards the phrase, the person interested, I agree with the respondent that the phrase has been examined in the case of Ivan versus Noble, where a person not interested in the outcome of an action has been described as a person who has no temptation to depart from the truth, one side or the other. a person not swayed by personal interest, but completely detached, judicial, impartial, independent. In other words, it contemplates that the person must be detached, independent, and non-participant, and really not interested which way in the context is false. Normally, a person who is performing an act in official capacity cannot be a person interested under Section 91 of Section 3, which is now the Section 83. I think the phrase, the person interested, ever more so has been quite definitely put in the case of Halton and Halton. Mean a person who has pecuniary or other material interest in the result of the proceeding. A person whose interest is affected by the result of the proceedings and therefore would have no temptation to pervert the truth to serve his personal, private ends. It does not mean an interest in the sense of intellectual observation or an interest purely due to sympathy. It means an interest in the legal sense, which imposes something to gain a loss. CPC and Ombukadu, when considering and determine who is a person interested under Section 91.3 of the Evidence and Truth and Official Task. By the provision of Section 91.3 Evidence Act, the person interested is a person who has a pecuniary or other material interest and is affected by the result of the proceeding, and therefore will have no temptation to pervert the truth, serve his personal private interest. In fact, it is in its most recent decision in Oyetola and another versus Annex, the Supreme Court, urging JSC restricted this position. The following words: the other evidence adduced by the appellant proved the case is the expert analysis prepared by PW1, who by his own admission is a member of the second appellant and had been a special assistant to the first appellant and was engaged by the appellant to establish the invalidity of the results from ECA for the 744 polling units. It is testified further that I made the report as directed by the petitioners and that I am part of those who wrote the petition. By his own testimony, he established that he was not an independent expert, as he had an interest in the subject of his analysis, carried out the analysis from the conclusion that the results were invalid. He testified to support the contemplated election petition. It was an analysis from an answer and not from a question. That report is not the product of an independent, impartial, detached, and professional analysis. It is clearly a person with the disposition or temptation to depart from the truth. The listing of the expert analysis report in the petition among the documents will be relied on to prove the petition show it was made in anticipation of contemplation to be filed. The report having been made by PW1 as a person interested in the subject matter of the petition, when the petition was anticipated to establish that the election result was invalid, not admissible evidence, by virtue of Section 83.3 of the Evidence Act 2011 as amended. Close of court. In the instant case, PW4, who claimed to be an expert, was contracted by the petitioners before the election to carry out data analysis on the results of the presidential elections held on 25th February 2020. He even tendered his letter of engagement as a second petitioner dated 20th February 2020, which was admitted in PCF2. According to him, he produced his initial report on 19th March 2023. His report was made a day before this petition was filed on March 20th, 2023. Obviously, the report exhibit PCD1, PCD3 was prepared in anticipation of this petition. As for PW7, who also claimed to be an expert witness, he admitted that she was not only a member of the second petitioner, but had contested the House of Representatives election under the platform of the second petitioner, which election was conducted the same day with the presidential election on the 25th of February 2023. He also admitted that the report she presented in the exhibit PCJ public information posted by Amazon, which she downloaded from the Amazon website, and that the open access information she downloaded in her report cannot be amended by her. This shows that PW7 was clearly not the maker of the said document. As for PW8, who claimed to be a cybersecurity expert, he stated under cross-examination by the first respondent that he was engaged by the second petitioner as an expert on 10th March 2023, and that he produced a preliminary report on 17th and 18th of March 2023, and final report, Exhibit PCK1, at the end of May 2023, while this proceeding pending. It is therefore evident from the above that PW4, PW7, and PW8 are persons interested in the outcome of this proceedings. The reports produced by PW4 and PW8 qualify as statements made by persons interested in anticipation or during the pendency of this petition. As for PW7, he is admittedly an interested party, having been a member of and even contested election under the umbrella of the second petitioner. Her interest is further underscored by the fact that she admitted under cross-examination that she was attending court throughout the proceedings prior to her evidence. By virtue of Section 83, Sub 3 of the Evidence Act 2011, the report tendered by those witnesses which form part of their evidence make it admissible. In view of the foregoing, exhibits PCD1, PCD3, PCE1, PCE4, PCG2, PCH1, PCJ1, PCJ2, PCJ3F, PCJ4, PCJ1, and PCJ4 tendered through the incompetent PW4, 5, 6, 7, 8 are hereby expunged from the record of this court. The second aspect of the respondent's objection is on the ground of improper certification or authentication. On the second respondent's objection, exhibit PDP1 to PDP21, the IRF report for Adamawa State on the ground that no certificate of authentication of those computer-generated documents was filed in compliance with Section 84 of the Evidence Act 2007. Exhibit PCB1 to PCB6, referred to by the petitioners in response to the objection, are IRF certificates of compliance for Bayelsa, Benue, Ekiti, Niger, Ogun, and Rivers States. Adamawa State is not included in those exhibits. Exhibit PCC1 to PCC28, which include Adamawa State, are actually diverse reports and their certificates of compliance. That of Adamawa is PCC21. In short, no certificate of compliance was produced by the first respondent in respect of PDP1, PDP21. The blood IRF report exhibit PCA series in respect of Adamawa State. However, since the documents were stated to have been downloaded from ANEX IRF portal and were certified by ANEX as true copies of what they have in their IRF portal, the documents qualify as public documents within the meaning of Section 102 of the Evidence Act 2011, and the certification by ANEX authenticates those documents. Therefore, the provision of Section 84 of the Evidence Act is not applicable. Yes. This is the position of the law as espoused by the Supreme Court in the case of Kubo and Dixon, where the Apex Court held that the computers of internet-generated documents printed from the website of a public institution is a public document, only a copy of such document which is duly certified in compliance with Section 104 of the Evidence Act 2007 admissible. That I've started the term of Supreme Court by Akas ASC Court. Exhibits PDP1 PD1 to PD21 having been downloaded from INEC report and duly certified by INEC are clearly admissible. As for the fourth respondent's objection to Exhibit PCG2, the flash drive ended by PW5, the staff of Arise TV, it is clear that the said witness had in paragraph 6 to 12 of his witness statement on oath not only stated that he participated in all stages of the recording, production, and packaging of the flash drive, but he had certified the process of his production as required by Section 84 of the Evidence Act. On the fourth respondent's objection to the admissibility of Exhibit X2, on the ground that the Exhibit X2 was obtained by the petitioner from the registrar of this court and not from the custodian of the original copy, we have examined Exhibit X2, which is the European Union Election Observation Mission Nigeria 2023 final report. As rightly observed by the first respondent, the photocopy of the document is certified by a secretary of the Presidential Election Petition Court and not any officer of the European Union Election Observation Mission, which is the custodian of the original copy of the document. By Section 104(1) of the Evidence Act 2011, secondary evidence of any public document only admissible in evidence if it has been certified by a public officer having custody of the original copy of the document, who by that section may give a copy of them to any person who has a right to inspect, together with a certificate written at the foot of such copy that it is a true copy of such document or part of it as the case may be. Under subsection 2 of that section, the public officer is enjoined to certify same by subscribing his name, official title, and date, and where he is authorized to use a seal is his seal. Clearly, the registrar of this court, who is not the custodian of the original copy of X2, cannot validly certify that document under Section 104(1) of the Evidence Act 2011. The Omisori and Arebashola Manuel Vasumana, where Mwezi JSC stated that the whole essence of the court's insistence on the scrupulous adherence to the certification requirements of public documents is to vouchsafe their authenticity vis-à-vis the original copies. Since Exhibit X2 has not been validly certified, it is inadmissible in evidence. Finally, Exhibit X2 is expunged from the record. The third aspect of the petitioner's objection to the petitioner's document is on the ground that the petitioners failed to plead specific facts over the documents objected to. The documents objected to by the respondents are exhibit. So many they have been listed in this judgment. Get the judgment, you will see them. I have carefully examined the petitioner's pleadings and the documents objected to by the respondents. The petitioners have specifically averred in paragraph 101 of the petition that they will be relying on all the first respondents' electoral and all other necessary documents used for the conduct of the presidential election, including the documents which they listed as items A to PCC, that paragraph. However, election petitions are sui generis, and it is settled that for an averment in an election petition to be competent, material facts relating to complaints made therein must be pleaded. Belgore, Ahmed, Yazu, and Oti. In the latter case of PDP and ANIC, the Supreme Court was categorical on this mandatory requirement for specificity and averments of election petitions when the court held as follows. On whether the affected paragraphs were rightly struck out, I have read the affected paragraphs and found that they relate to allegations of non-voting, several polling points, corruption of election, non-conclusion of election, some printing of ballot papers, falsification of election results, widespread disruption, irregularities and malpractices without providing particulars, or the polling units where the alleged malpractice took place. Lower court was therefore right when it held as follows. Paragraphs above, in my view, are too generic, vague, and lacking in any particulars, as they are not tied specifically to any particular polling unit or any particular number of people who were alleged to die. The fact that a party can file further particulars or deny in a reply a vermin in the pleading must not be general, it must be specific as to facts. A certain law that a petitioner's obligation particulars of fraud or falsification, that which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above. I adopt it as mine. Those of court. That's why allegations of non-compliance and corrupt practices are made, such as in the institution, the polling unit, or other places where those irregularities and matters have disability. The petitioners have that the issue of non-compliance by the first respondent, its laws, guidelines, and relevant statutes is a universal complaint because it is an infraction against the Nigerian people, the Nigerian state. However, this contention of the petitioners is not in consonance with the requirement of the law as espoused in Belgore and Ahmed, PDP and INEC. This is more so as the petitioner's allegation of non-compliance is interwoven with allegations of corrupt practice in court. In the instant case, the petitioner tendered following documents which have been listed in this judgment. However, a look at the entire petition shows that no single petition complaint was made by the petitioners in respect of any of those cases as to make those exhibits relevant to the petitioner's case. For instance, in paragraph 72, which the petitioners referred in response to the objection, the petitioners have alleged that there was overvoting in the states of Oyo, Bondo, Taraba, Osun, Kano, Rivers, Borno, Katsina, Para, Gombe, Yobe, and Niger State. However, the petitioners failed to specify the polling units where the overvoting took place, the total number of accredited voters, the total number of votes cast, and the number of votes deducted from the scores of the parties. Similarly, in paragraph 73, which was also referred to by the petitioners in their response to the objection, the petitioners have averred that based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process for computation of the result and disfavored the petitioners, and listed the states of Rivers, Lagos, Taraba, Benue, Adama, Imo, Bauchi, Borno, Kaduna, Plateau, and other states of federation. But the petitioner failed to state the scores improperly computed and how they were disfavored. As regards the objection to exhibits PCA, PCE1 to PCE4, said to be 18,084 and 88 blood results downloaded from IRF and contained in 4 boxes. The petitioners have contended that the petitioners' request for the petitioners to specify the 18,088 polling units, which those blood reports relate, is an impossibility because the results are readable. The details of most of the polling units are stated in PCD1 to PCD3, the expert report tendered by PW4. This contention of the petitioners is, however, misconceived. This is because the petitioners who claim that they could not specify the polling units in the 18,000 because those results are unreadable are the same persons who have stated that the same polling units have been specified in the expert report of PW4, through whom the blood results were tendered. However, PW4 stated under cross-examination that the primary source of the data he used in producing his report was the IRF portal. He did not state how he was able to determine the particular polling units and the impacted votes, accredited voters, and the number of PVCs collected. As I earlier noted, PW4's report was concluded on 19th March 2023 before the petitioners filed this petition on 20th March 2023, which means the petitioners were aware of the polling units to which their complaints had led even before they filed the petition. So their theory of impossibility, which they invented around the 18,088 blood results, is misconceived and an obvious misadventure. Again, in paragraphs 7 and 8 of the petition, The petitioners admitted that they have agents in the polling units, and those agents signed and collected duplicate copies of the result sheets. Those paragraphs read as follows. Paragraph 7. The petitioner is a body corporate with perpetual succession and in sponsorship of the first petitioner and the conduct of the election thereby. Acted through its members appointed as agents at all stages of the election, namely at the polling units, the ward collation centers, the local government collation centers, the state collation centers, and the ultimate collation center at the federal level in Abuja. Paragraph 8. In the conduct of the election, the agents duly appointed by the petitioners performed their assigned and statutorily designated roles at the election. These roles included observing and monitoring the process of arrival of election materials, where they were supplied by the respondent, and leading to and including the process of accreditation, voting, counting of votes, and announcement of the results of the election. These agents were the election proceeded in due form, and the respondent agents duly entering the results in the result sheets at the polling unit, signed and collected duplicate copies of the result sheets. Having clearly admitted that their agents signed and collected duplicate copies of the result sheets, their contention that they are unable to determine the polling units from which the blood results emanated is untrue. In fact, this admission reinforces the need for the petitioner to spy upon in respect of which they made complaints, since their agents were availed with copies of the results of the polling units. As regards the petitioner's contention that they have complied with paragraphs 4, 5C, and 41A of the first schedule of the Electoral Act 2022, I had earlier considered this argument for the petitioner while resolving the corresponding objection to petitioner's readings, wherein we held that the provision of paragraph 4, 5C of the first schedule to the Electoral Act 2022 only relates to the front-loading documents to be relied upon by the petitioners as their evidence during trial. It does not obviate the mandatory requirement for pleading materials stated in paragraph 41(1)(d) and 2 and 41A of the same schedule. Also enable the advanced party to know the exact case he is to meet and to respond to them accordingly. As stated in our earlier ruling, the reports which the petitioner stated they had detailed the polling units was not filed along with the petition, so as to afford the respondent the opportunity to respond to them, but was merely tendered at trial, by which time the respondent had no opportunity to respond. Then the petitioners have failed to specify in the petition the polling units to which exhibit PCA1, PCA4, the 18,088 ballot results relate. The state documents are clearly inadmissible. State exhibits thereby discountenance and demands from the record. We now go to petitioner objections to the respondent's documents. In the course of trial, the petitioner also objected to the documents tendered by the first and second and third respondents at the hearing of the 4th of July 2023. First respondent had tendered exhibits RA1, RA2, RA3, RA4, F5, 6, and 7 through his sole witness, Dr. Lawrence Ayode, a deputy director in the SCT department of the first respondent, who gave evidence as RW1. Of those documents, the petitioners had objected to the admissibility of exhibits RA1, RA2, RA6, and RA7. Similarly, at the hearing of the 5th of July 2023, the petitioners had objected to all the documents tendered by the second and third respondents from the bar and through their sole witness, Senator Michael Okemi Bamidele, who testified as RW2. The petitioners had reserved their reasons for the objection to be adduced at the stage of final address. Pursuant to the order of this court, the parties will file separate addresses on their objections. The petitioners have filed separate addresses in support of their objections to the documents of the first respondent and those of the second and third respondent. A written address in support of the objection of the respondent document was filed on 23 July 2023, while that in support of the objection to the second and third respondent documents was filed on 20th July 2023. In the written address in support of the petitioner's objection to the first respondent document, Dr. Livy Uzoku, Land Senior Counsel for the petitioners, essentially raised the sole issue of whether, with regard to the pre-hearing report of 23rd May 2023, paragraph 41 of 3 of the first schedule to Electoral Act 2022 and other relevant provisions of the Act and decided cases, exhibits R8, 1, 2, 6, and 7 are inadmissible and liable to be exchanged from the evidence. Similarly, in the address in support of the objection to the second and third respondent document, the petitioner raised the sole issue of whether, with regard to the said pre-hearing session report and paragraph 41(3) of the first schedule and decided cases, the documents tendered by the second and third respondents are inadmissible and liable to be expunged from evidence. Plaintiff pointed out that Exhibit RA1 is a private document emanating from the third respondent and argued that in the absence of the narrow exceptions to the maker of the document, being the person to tender the document, the witness of the first respondent, thus RW1, cannot tender same in evidence. He relied on Main Street Bank Limited and General Mills Others Limited. National Council also submitted that Exhibit RA2 is inadmissible because the first respondent cannot appropriate at the same time. Since Exhibit RA2, first respondent is trying to deny another letter received by it from the court of 2020, which he had also certified. We'll just go direct to the resolution. Yes. So by virtue of the provisions of Section 102B of the Evidence Act 2011, public documents include public records kept in Nigeria of private documents. In the case of Onwuzurike and Dozium and others, where the Supreme Court by Onogen then was held that a private document sent to the police form part of the record and of the police and is transferred to the document within the provision of Section 109 of the Code of the Evidence Act, now Section 102 of the Extant Evidence Act 2011. Also tried that a public document duly sourced satisfied is admissible in evidence, notwithstanding that it is not tendered by the maker. Indeed, a certified true copy of a public document can be tendered by a person who is not a party. Yes, be the case of Aranro and ATBC, Dash and Bulama, Mustafa, Fatima and others versus Al-Haji Bukar of Customs. Exhibits RA1 and RA2 being in the public record of the first respondent are public documents and are therefore admissible when been certified by the first respondent under 104 of the Evidence Act 2011. On the petitioner objection to exhibits RA6 and RA7, the record of proceedings of this court for July 2023 shows that contrary to the assertion of the petitioners, said exhibits RA6 and RA7, which are the cloud trail log and certificate of compliance to Section 84 of the Evidence Act respectively, were not tendered from the bar but through RW1. Indeed, the record shows that the petitioners consented to the said documents being taken as read and demonstrated, therefore have no hesitation in this countenancing the petitioner's objection to those documents. On the whole, the petitioner's objection to RA1, RA2, RA6, and RA7 tendered first respondents and meritorious, it is hereby overruled. Now go to objection to the petition objection to the second and third respondents' documents. We consider the The resolution of that objection on the petitioner objection to exhibits RA8 and RA9. An examination of the petition shows that in paragraph 28, they have challenged the second respondent qualification to contest the election on the ground that he was fined sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division. As rightfully submitted by the second and third respondents, they have countered this allegation of the petitioners in paragraph 46 to 53, and particularly pleaded in paragraph 50 that the United States of America, through its embassy in Nigeria, had by a letter dated February 4, 2003, addressed the then Inspector General of Police and confirmed that upon their record checks of the Federal Bureau of Investigation, National Crime Investigation Center, NCIC, the centralized information center that maintains records of every criminal arrest and conviction within the United States of America, there were no record of any form of criminal arrest, warrants against the second respondent. The respondent shall found and rely upon a copy of the said letter of February 4, 2023, signed by Michael M. Bonner. Yes. The date is wrongly stated, corrected. From the foregoing, it is obvious that issues were joined by the parties on the indictment alleged by the petitioners, and exhibits RA8 and RA9 are clearly relevant. As for the argument of the petitioner over the custody of the documents, exhibit RA8 is a letter of inquiry written by the Inspector General of Police to the Consulate General of the United States Embassy in Nigeria, inquiring as to whether the second respondent had any criminal record in the United States of America, while exhibit RA9 is replied is RA8 by the United States Embassy in Nigeria. Both letters form part of the record of the Nigeria Police and are therefore public documents under Section 102E of the Evidence Act. Certification by the Nigeria Police Force is a confirmation that exhibits RA8 and RA9 are true copies of those documents which are in their custody. Onwuzurike and Idoziem, Abaji and Koka. With regard to the petition objection to the relevance of exhibit R10, the record shows that the petitioner's challenge to the qualification of the second respondent was confined to allegations of double nomination of his enemy, third respondent, and the alleged fine of the second respondent of the sum of $460,000 by a United States court. The educational qualifications of the second respondent were not alleged by the petitioners in this petition. It was the second and third respondents who introduced the educational qualifications of the second respondent in their reply, and the petitioner have not joined issues with the second and third respondents in their reply to the second and third respondent reply. That the court of law adjudicates only on matters over which parties are in dispute. The DDG and Olosho and another Trade Bank PLC versus General of Nigeria Limited. Since there is no controversy or dispute between the parties as it relates to the second respondent educational qualifications, exhibit RA10 is not relevant to the commission of this question, thereby spontaneous. Our examination of exhibits RA11 to RA16, which are data pages and visa pages in the second respondent Nigerian passport, show that contrary to the assertion of the petitioners that the documents are not relevant, the petitioner have alleged in paragraph 28 to 32 of the petition that the second respondent was fined $460,000 for an offense involving dishonesty, namely narcotics trafficking. In response to this allegation, the second and third respondents have denied same in paragraph 46 to 53 of their reply, and specifically pleaded those documents in paragraph 52 of their reply to the petition. To show that the second respondent enjoyed an unrestricted right of ingress and egress to the United States of America, and up till now, he still enjoys an unimpeded right of access to the United States of America. It is therefore a considered view that Exhibit RA 11 and RA 16 are relevant to these proceedings. It is no objection to them, thereby discountenance. As for Exhibits RA 17 and RA 18, the petitioner's reason for objection to the same has nothing to do with the admissibility of the documents. Second tier respondents having raised objection to the first petition's locus standi to present the petition in paragraphs 1 A to M of their reply to the petition. However, we have already considered and determined the issue of the petitioner's locus standi whilst resolving the respondents' no objections. We have already resolved same in favor of the petitioners. Therefore, this objection has been taken by our ruling with no objection. On the petitioner contention that Exhibit RA 19, the report of the committee on the location of the federal capital Nigeria, is not relevant. We have examined the pleadings and the said exhibit. It is apparent to us that while the petitioners have averred in paragraph 81 of the petition that the presidential candidate must score 25% of the votes in FCT before he can be declared and return elected, the second and third respondents have averred in paragraph 86 of their reply that the FCT does not enjoy a special status over the other states of the Federation, and that Abuja is still inhabited by Nigerians who are deemed equal to Nigerians in any other part of Nigeria, and residents of Abuja are not conferred with any privilege and advantage that is not accorded to certain other communities or states in Nigeria. We are therefore of the view that facts have been pleaded which rendered Exhibit RA 19 relevant. On the petitioner's objection to the admissibility of Exhibit RA 22, we observe that the document is the same as Exhibit RA 2, which we have already found to be admissible, having been certified by ANIC as a copy of document in their possession. Tender of Exhibit RA 22, which is not even certified, is therefore a surplusage, thereby discountenance. With regard to the objection admissibility of Exhibits RA 24 and RA 25, which are CTCs of pages 28 and 29 and 27 of Nigerian Tribune newspapers, respectively. The reasons advanced for the objection of the petitions are not legal grounds for challenging admissibility of the document. We have no hesitation in discounting the objection, contrary to the arguments of the second and third respondents' counsel that Exhibit RA 27, the preliminary declaration, is a private document. Said document forms part of the official record of the Economic Community of West African States, ECOWAS, an official body established under ECOWAS Treaty. An agreement made by member states of the ECOWAS community, and the treaty was signed by heads of states, government of the 16 member states. It's undoubtedly a public document within the meaning of Section 102 of the Evidence Act 2012. However, we observe that Exhibit RA 27 is not certified as required by Section 104 of the Evidence Act to render same admissible. Not being so certified, Exhibit RA 27 is hereby expunged from the record. As for the objection to Exhibit RA 28 being the American Bar Association membership card of RW2, which was tendered by RW2 under cross-examination by the fourth respondent, it's clear to us that the document was neither pleaded nor listed or referred to in the statement of RW2, as rightly argued by the petitioners. Exhibit RA 28 is inadmissible when it is thereby expunged record. Now we go to the merit of the petition. Well, having disposed of the various objections to witnesses and to some of the documents tendered in this petition, we now proceed to consider the merit of the petition. The parties filed extensions and adopted their respective final written addresses, starting with the respondents. The respective final addresses of the first, second, and third, and fourth respondent were filed on the 14th July 2023, respectively. On the 23rd of July 2023, 20th July 2023, and 23rd July 2023, the petitioners filed 3 separate final addresses in response to the final addresses of the first, second, and third, and fourth respondents, respectively. In reaction to the petitioners' final addresses, the first, second, and third and fourth respondents filed their reply addresses on 28th July 2023 and 1st July 2023 and 10th July 2023, respectively. The first respondent and the second and third respondent also filed lists of additional authorities on the 28th and 31st of July 2023, respectively. On the 1st of August 2023, the parties adopted their respective final addresses. In his adopted final written address, Learned Senior Counsel for the first respondent, A.B. Mahmoud SN, distilled the following 5 issues for determination. A. Whether having regard to the provision of Section 131 and 137 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the evidence before the court, second and third respondents were qualified to contest the presidential election 25th February 2023. Having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraph 38 and 92 of the regulations and guidelines for the conduct of the election 2022, the inability of the first respondent to transfer or transmit the results of the presidential election to the IRA portal real time amounted to non-compliance with the Electoral Act, whether such non-compliance substantially affected the outcome of the election. 3. Whether by the totality of evidence adduced, the petitioners have proven that the election of the second respondent was invalid by reason of corrupt practices, non-compliance with the provisions of the Electoral Act 2022. 3. Whether in the absence of any proof of lawful and unlawful votes to be added to the scores of the petitioners and or unlawful votes to be deducted from the second respondent's scores at the election, the petitioners have proven that the second respondent was elected by majority lawful votes cast. B. Whether having regard to the declared results of the election and the provision of Section 134, subsection 2B of the Constitution of the Federal Republic of Nigeria 1999 as amended, the second respondent ought to have been returned as duly elected after having scored the highest number of votes, as with 25% of the votes cast in over 2/3 of the state's federation. Learned Senior Advocate for the second and third respondents, Chief Wale Olanipekun, formulated the following 4 issues for the determination. 1. Having regard to the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, salient provisions of the Electoral Act 2022, judgment of Federal High Court, and FAC ABJCS 1454/2022, Labour Party and ANIC delivered on 23rd January 2023, which is X1, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 26 February 2023 was not in substantial compliance with the principles and the provisions of the Electoral Act 2022. 2. In view of the clear provisions of the Constitution of the Federal Republic of Nigeria 1999, the Electoral Act 2022, regulatory of judicial precedents and the criteria for qualification of candidates for election to the office of President, coupled with the unreported decision of the Supreme Court in SC/501/2023, People's Democratic Party vs. Independent National Electoral Commission (INEC), delivered on 26 May 2023, Exhibit RA23, whether the second and third respondents were or are not eminently qualified to contest the presidential election of 26 February 2023. 3. Upon a combined reading of sections 134 and 299, as well as other relevant sections of the Constitution of the Federal Republic of Nigeria 1999 as amended, Section 66 of the Electoral Act 2022 and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. 4. Considering the constitution of petition and the task evidence adduced, whether this honorable court can accede to the reliefs being claimed by the petitioners. Prince L.O. Fademi SN, Senior Counsel for the fourth responder, also nominated 4 issues for termination as follows. 1. Whether having regard to the issues joined and the evidence led on the nomination of the third respondent as vice presidential candidate of the second respondent and the annulled civil forfeiture of the alleged civil forfeiture of the sum of $460,000 to the United States by order of the district court, case number 93C-0483. The petitioners have established that the second respondent was not qualified to contest the presidential election held on 26 February 2023 as provided for in the Constitution of the Federal Republic of Nigeria 1999 as altered. 2. Whether having regard to the relevant and admissible evidence led by a party, the conduct of the presidential election held on 26 February 2023 election was vitiated by non-compliance that was substantial enough to have affected its outcome and justified nullification of the election as envisaged by the applicable provisions of the Electoral Act 2022. 3. Whether the burden of proving that first petitioner and not second petitioner scored majority of lawful votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 26 February 2023 has been discharged by the petitioners. 4. Whether having regard to the totality of the evidence by the parties and the applicable law, the petitioners are entitled to succeed on any of the relief sought in the petition at all, or that the petition ought to be dismissed in favor of the respondent. On the part of the petitioners, their lead senior counsel, Dr. Livy Uzoku SN, still the following 3 issues in the petitioner's final address in response to the final address of the first and fourth respondents. 1. Whether the second and third respondents are qualified to contest the presidential election by reason of the unchallenged facts and circumstances arising under Section 137, Subsection 1D, 142, Subsection 1 and 2 of the 1999 Constitution, Section 35 of the Electoral Act 2022. 2. Whether from the documentary evidence before the Honorable Court read and examined together with the unchallenged expert and technical evidence of the petition witnesses, the petitioners proved that the non-compliance by the first respondent with the relevant provisions of the Electoral Act 2022 and the subsidiary legislation made thereunder substantially affected the outcome of the questioned presidential election held on 26 February 2023. In response to the second and third respondent final address, the petitioners adopted issues 1 to 3 of the issues for termination with the earlier filed on 18th May 2023 during the pre-hearing session. These are 1. Whether the second respondent at the time of the presidential election held on 26th day of February 2023 was not disqualified to contest the said election by virtue of the provision section 1371D of the Constitution of the Federal Republic of Nigeria ended. 2. Whether the third respondent at the time of the presidential election held on 26 February 2023 was qualified to contest the said election as the vice presidential candidate to the second respondent. If answered in the negative, whether this did not invalidate the qualification of the second respondent to the election. 3. Whether the presidential election held on 26 February 2023, wherein the second respondent was declared and returned by the first respondent as the winner, was not invalid by reason of non-compliance with the provisions of the Electoral Act 2022 and any guidelines and regulations for the conduct of the election 2022 made pursuant to the Act. From the pleadings, the evidence adduced and the submissions of counsel of the parties, it is a considered view that the following are the issues which will effectively determine this petition. 1. whether having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria 99 as amended, Section 35 of the Electoral Act 2022, and the evidence and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 26 February 2023. 2. Whether having regard to the evidence adduced by the parties, the petitioners have established that there was substantial non-compliance with the provisions of the Electoral Act 2022, and that the non-compliance substantially affected the results of the election. 3. Whether from the totality of the evidence adduced, the petitioners have proven that the presidential election held on 26 February 2023 was invalid by reason of corrupt practice. 4. Whether from the evidence adduced, the petitioners have established that the second respondent was not duly elected by majority of lawful votes as at the election. We stated earlier, we have summarized this submission of the council in one of reading them out.
Èmi ti mọ̀ pé ẹ̀ ní ẹ̀ lè kàbò. Ẹ máa waste time àwọn èèyàn ni.
The first issue is whether having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria as amended, Section 35 of the Electoral Act, and the evidence for the court, second and third respondents were qualified to contest the presidential election of 26 February 2023.
Èmi mọ̀ pé ẹ̀ lè kàbò. Ẹ máa waste time àwọn èèyàn.
Well, I think
waste time àwọn
issue of qualification has been resolved in petition number 4. It's the same issue that has been raised here. So we stand by our resolution. This issue. The only exception is the allegation on the issue of second allegation made by the petitioners in ground 1, which is contained in paragraphs 28 to 30 of the petition, is that the second respondent is disqualified from contesting the presidential election because is stated in paragraph 28 of the petition as follows. The petitioner further pleaded that the second respondent was also at the time of the election not qualified to contest for election to the office of president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C4483 between United States of America plaintiff versus funds in the account of 26322700 held by First Heritage Bank in the name of Bola Tinubu. Funds in the accounts 394833134, 394833396, 4650279566 held by Citibank NA in the name of Bola Tinubu or Compass Finance and Investment Company. Funds in the accounts number that are held by Citibank International in the name of Bola Tinubu Pendants. The petitioners have pleaded and relied on the order of the U.S. Court in Exhibit P5, which they tendered from the bar, and which was subsequently identified by PW2 and PW12 in their evidence earlier summarized. The petitioners have centered their contention on the provisions of Section 137, subsection 1G of the 1999 Constitution, which reads as follows. A person shall not be qualified for election to the office of president if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or sentence of imprisonment or fine or any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed by him by any court, tribunal, or substituted by a competent court, by a competent authority, or any other sentence imposed on him by such court or tribunal. A careful examination of the above provision shows that the operative words of that paragraph of the section are sentence, imprisonment, fine, and for any offense. Black's Law Dictionary 6th edition at page 1081 defines offense as quote, a felony or a misdemeanor, a breach of the criminal laws, violation of law for which penalty prescribed. The word offense, while sometimes used in various senses, generally implies a felony or a misdemeanor, infringing public as distinguished from mere private rights. As unpunishable under the criminal laws, though it may also include the violation of a criminal statute, which the remedy is merely a civil suit to recover the penalty, an act clearly prohibited by the lawful authority of the state providing notice through public laws, clause of court. Also, the Supreme Court, in the case of Abdullahi Umar and the state, held that an offense is an act which is clearly prohibited by law and which may be a crime or a civil offense. Sentence, on the other hand, has been defined by the same Black Law Dictionary at page 1362 as follows. The judgment formally pronounced by the court or judge upon the defendant after his conviction in a criminal prosecution, imposing the punishment to be inflicted, usually in the form of a fine, incarceration, or probation. Again, this court also defined sentencing in Yakubu and the state as follows. The judicial determination of a legal sanction to be imposed on a person found guilty of an offense. It means the prescription of a particular punishment by a court to someone convicted of a crime. It is discernible from the above that the fine referred to in paragraph E of section 137(1) quoted above is one which emanates from a sentence for a criminal offense involving dishonesty or fraud. The words for imprisonment or fine also which is imposed as an alternative to the imprisonment. In other words, section 137, subsection 1D relates to sentence of death or sentence of imprisonment or fine imposed as a result of a criminal trial conviction. Indeed, in considering the offense that can amount to disqualification under section 1371 of the Constitution, the Supreme Court held in Action Congress versus ANIC as follows. The disqualification in section 137, subsection 1 clearly involves a deprivation of right and a presumption of guilt or embezzlement or fraud in derogation of the safeguards in section 36, subsection 1 and 5 of the Constitution. The trial and conviction by a court is the only constitutionally permitted way to prove guilt, and therefore the only ground for the imposition of criminal punishment or penalty for the criminal offense of embezzlement or fraud. Clearly, imposition of the penalty